We're on agenda item number 9, original 16-1 Mine Inc. This is time and place for a public hearing to consider an administrative civil liability order for original 16-1 Mine of Sierra County. The designated parties for this proceedings are as follows. It's the original 16-1 Mine. All other parties are considered interested persons. The prosecution team has a combined total of 30 minutes for direct testimony, cross-examination, and a closing statement. The original 16-1 Mine has a combined total of 25 minutes for the same. Interested persons shall limit their comments to 3 minutes and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the truth, do you swear the testimony you're about to give is the truth? If so, answer, I do. Thank you. At this time, evidence should be introduced on the following issues. Whether the board should issue, reject, or modify the proposed ACL order. The order of this hearing is as follows. We'll begin with testimony by the prosecution team. That'll be followed by testimony by the original 16-1 Mine. That'll be followed by cross-examination of the prosecution team, then cross-examination of the original 16-1 Mine. Then we'll move on to comments by interested persons, and that'll be followed up by closing statement by the original 16-1 Mine, followed by a closing statement from the prosecution team. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranca Rosardi, our administrative assistant sitting here at the table. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
There was a late comment letter submitted by Mr. Miller, which the chair, after reviewing it, denied inclusion into the record.
Thank you.
I had a question here on these late letters. They still have the option to come and talk to us directly, though, right? I mean, you deny it because they missed the deadline, but there's still the option to come to the meeting and talk.
Absolutely.
Okay.
Are there any procedural issues that the designated parties would like to raise? Certainly, and hopefully it's on. No, it's not. You need to push the button.
My name is Michael Meister Miller. My address is P.O. Box 941, Allegheny, California, 95910. I'm a president and director and a California gold miner. I'm in Rancho Cordova. I do have some legal questions, and I couldn't quite follow if this is the appropriate time to bring those. All I need is some advice.
Go ahead and ask, and we'll let counsel advise.
There are abundance of legal questions regarding the Port of Cologne Act and also the Federal Clean Water Act and the definition and uses and requirements of those acts versus what's occurring at the in Allegheny at the 16-1 Mine. I just don't want to lose the opportunity, but I can certainly wait. I'll do what I'm supposed to do as far as addressing these.
So I think those are actually parts of your legal arguments that you'll be making, so that should be done at your time. This is for if you had any legal questions with regard to the process or the hearing itself.
Oh, thank you very much for that explanation. I have none.
Thank you. We'll then move to testimony by the prosecution team.
May I begin? Okay. Good morning, Dr. Longley and members of the board. My name is Ida Soltani, and I'm an engineer of the NPDES Compliance and Enforcement Unit here in the Rancho Cordova office, and I have taken the oath. We're here today to ask the board to adopt an administrative civil liability order against the original 16-1 mine for mandatory minimum penalties for violation of its NPDES permit. Before we discuss the details of the order, I want to give you a brief overview of how mandatory minimum penalties, or MMPs, are assessed, history of the mine, current mining operation, and regulatory history of 16-1. Then I will turn it over to Xuan Liu, who will discuss the details of the proposed order. In 2000, the state enacted a mandatory minimum penalty structure for violation of NPDES permits. Water Code Section 13385 requires the assessment of MMPs for serious violations and for non-serious or chronic violations when more than 4 violations occur within 180 days. There is no latitude on this penalty. The state has determined that violations of this nature must be assessed a minimum penalty of $3,000 per violation. Water Code Section 13385 defines a serious violation as any waste discharge that violates the effluent limitations contained in the applicable waste discharge requirements for a Group 1 pollutant by 40% or more and a Group 2 pollutant by 20% or more. Group 1 priority pollutants include oxygen demand, solids, nutrients, detergents and oils, minerals, and some metals. Group 2 priority pollutants include some metals, inorganics, and organics. Any other effluent violations not in Group 1 or 2 are considered non-serious violation. The first 3 non-serious violations within a 180-day period are not subject to MMPs, but discretionary penalties may be assessed for these violations. Non-serious violations are subject to MMPs if there are 4 or more violations within a 180-day period. MMPs are the minimum required penalty that board staff must impose for serious violations. Alternatively, the board may impose a discretionary penalty for a total of up to $10,000 per day of violation plus $10 per gallon discharge over 1,000 gallons. Unlike with discretionary penalties, we do not go through the enforcement policy's penalty methodology when assessing MMPs. The order we're asking you to adopt is only for effluent violations subject to MMPs and does not include discretionary penalties. The Water Code does allow for protection from MMPs in certain circumstances. When a permit is adopted that contains effluent limits, which the discharger cannot immediately comply with, the board may choose to adopt an accompanying order, such as a time schedule order or cease desist order. The discharger is given interim effluent limits in the order allowing them time to comply with the limits in the permit. If the discharger exceeds the interim effluent limits in the TSO or CDO, MMP protection is lost for that reporting period. Now we will discuss the history of the mine. 16-1 is located in Allegheny, California, a small community in Sierra County. The western slope of the Sierra Nevada mountains is also known as Gold Country. This historic area is famous for mineral deposits and gold mines. Currently, the discharger collects loose rock that has been blasted from the working surface of the mine. Specimen gold is sold as is, and the rest is milled by hand. The groundwater and rainwater percolate through the mine waste, and as water migrates through the waste, it picks up soluble minerals that are carried into Kanaka Creek with runoff. This runoff has a high mineral content that, left untreated, will impact water quality. Although the discharger is considering to install a permanent passive treatment system at the portal prior to discharge to the creek, there is currently no treatment or control for the mine's wastewater. The mine discharges wastewater via the 21-tunnel portal to Kanaka Creek, a water of the United States and a tributary to Yuba River. The basin plan does not specify beneficial uses for Conacher Creek, but does identify present and potential uses for Yuba River. Multiple beneficial uses are applicable to Yuba River, such as municipal and domestic supply, which is intended to protect human health, and cold freshwater habitat intended to protect aquatic life. In order to protect these beneficial uses, the Central Valley Water Board issued a waste discharge requirements, which we will refer to as WDRs, or the permit, throughout the remainder of the presentation. 16:1's permit contains limitations so that the runoff from mining activity does not degrade water quality. Next, I will discuss the Regional Board's regulatory history of the mine. The previous WDRs were adopted in 2002, and a CDO was adopted as well to allow the discharger time to comply. The current WDRs were adopted in February 2015. The effluent limits are based on analytical data collected by board staff. During the permitting process, the discharger demonstrated that it would not be able to comply with the effluent limits in the 2015 WDRs, and therefore the board also adopted a time schedule order. The purpose of the TSO is to allow time for the discharger to develop a control or treatment option that will ultimately result in compliance with the effluent limits in the WDRs. The TSO requires the treatment or control to be installed by April 2020. In addition, the TSO contains interim effluent limits for multiple constituents. As I mentioned earlier, if the discharger complies with these interim limits, then it is protected from MMPs. However, if the discharger exceeds the interim effluent limits in the TSO, it loses protection for that constituent during that reporting period and is therefore subject to MMPs. On April 6, 2018, the board amended 2015 TSO based on new information provided by the discharger. Interim limitations were established in 2015 TSO based on limited data set. Since adoption of 2015 WDRs, the discharger has conducted 10 quarterly effluent monitoring events. The amended TSO revised the interim effluent limitation to better represent variability of the discharge. The discharger has no effluent violations of the constituents under the protection of the amended TSO since April 2018. Now I'll turn it over to Xuan Liu, who will discuss the proposed ACLO.
Good afternoon, Dr. Longley and members of the board. My name is Xuan Luo. I'm the senior engineer in the MPDS Compliance Enforcement Unit here in the Rancho Cordova office, and I have taken the oath. As Ida mentioned, this order only addresses MMP for violations of effluent limits. This table here shows the measure results reported by the discharger along with the WDR limits and the 2015 TSO limits. The Assistant Executive Officer issued a complaint in March for these violations, which occurred from January 2017 to December 2018. There are 7 total violations for this time frame. However, only 4 are subject to MMPs. 4 arsenic violations exceed the inherent limits of the 2015 TSO. As a result, the discharger lost MMP protection for these violations, and therefore the permits limit for arsenic apply. Because these exceedance are serious violations, they're each subject to a $3,000 MMP. As such, a total of $12,000 in MMP applies to 4 violations, which is proposed by this order. The prosecution team identified 3 main arguments raised by the discharger in its evidence submission. The discharger contends that the imposition of penalty in this case is not consistent with Porter Colon Water Quality Control Act. The prosecution team disagrees. The legislature's enactment of mandatory minimum penalties was to protect water quality by creating a swift enforcement mechanism to increase compliance with WDRs. The discharge's second argument is that the facility is not discharging waste. The facility is discharging waste, and staff has determined that regulating the discharge continues to be necessary to protect water quality. In addition, an enforcement action is not the appropriate forum to attack the validity of the WDRs. The discharge's third argument is mining districts should regulate mines based on the Mining Act of 1866. The Mining Act of 1866 related to property rights of miners, and the discharge's argument that the state should not be allowed to regulate the facility is without merit. In summary, the discharger exceeds the effluent limits in the 2015 WDRs for multiple constituents. Although the TSO contains inner limits for arsenic, MMP protection was lost when the inner limits were exceeded. The Water Code requires assessment of mandatory minimum penalties in the amount of $3,000 per serious violation. In this case, there are 4 serious violations, resulting in a total penalty of $12,000. The prosecution team recommends the board to adopt the proposed administrative civil liability order in the amount of $12,000. This ends our presentation. I'd like to enter this presentation into the record, and I'd be happy to answer any questions you may have. Thank you.
Questions? Thank you very much.
Thank you.
We're ready for, is that the end of the prosecution team's testimony? Thank you. We're ready for testimony by the original 16-1 mine. It's not red. You've got to push that button there.
Thank you.
There you go.
Again, my name is Michael Miller.
And for the record this time, give your address again and also whether or not you've taken the oath.
Okay. My name is Michael Meister Miller. My address is P.O. Box 941, Allegheny, California, 95910. My occupation is a California gold miner, and I'm president and director of a 107-year-old California corporation called Original 16-1 Mine, and I'm currently in Rancho. Where in the hell am I?
Rancho Cordova.
Rancho Cordova. It was a little tiny town when I grew up here. I was born and raised in Sacramento. I'm a sixth generation Californian, and went to school at Bret Harte, Cal Junior High, McClatchy. Graduated from UC Santa Barbara, stayed down there for a number of years and decided to come back to Northern California. Learned about mining opportunity through my father, who was a graduate of Sac High, and my mother as well, and decided to give it 5 years, and that was in 1974.
And, sir, for the record, I saw you take the oath, but...
Oh, I'm sorry. I took the oath.
Thank you. I saw you take it, so... Very good.
You have my resume and in your exhibits. It was part of my exhibit, but I noticed that there were some things that might not be on there. I think that integrity, honesty, and truth are vital to anybody who steps before here and makes statements. And I think that this is one of the concerns that I have. I don't have any argument with the staff, and I don't have any argument with the staff that helped me or the people that I've talked to over the last probably 30 years.
Please take down the presentation from the prosecution team.
Oh, sure.
Sorry, it was a logistical issue.
No, it's better, I think, too. I have some issues with you, and I remember one of you said about uncomfortable situations, and I've been before this board many times, going back probably 20 years. And I was at your Fresno meeting, made a presentation. I've also had attorneys with me before. The last time I was here in Sacramento, and I've had water experts. And perhaps this is a good time to mention Rob Campbell. I take great issue with him not being able to allow his report in. I sent an email. I didn't get the denial until about 4:30 last night or yesterday when I got back to my office. And there are reasons why you can accept it. And the main one is if there's a legitimate reason why Mr. Campbell can't be here. Perhaps you all have not seen the letter. I think the chairman did. But he said, Dear board, I have relayed to Mr. Miller that I cannot attend the meeting on June 6th. By the way, he told me this Monday. Due to a family illness, my brother may have non-Hodgkin's lymphoma, and Thursday he goes to the hospital for a formal diagnosis. He also said that he was expecting some other type of what?
Excuse me, Susie Laskatoff, attorney for the prosecution team. We object to this. This is the evidence that we had submitted a motion on to be excluded, and the chair already ruled on this.
Yes, Ms. Yar.
So, Mr. Miller can read this into the record. However, everything he is reading is considered hearsay because Mr. Campbell is not here to say it, and so the board has to take it as hearsay. But if he would like to use his time to read that into the record, that's fine. But it as the rule was, it was not going to be presented to the board ahead of time.
Stop the clock.
So
I do not need to read it into the record. The record will speak for itself. And I'm objecting to the decision by the chairman not to allow the rest of the board members to hear it. And I think there's enough legal precedent on this for hearsay argument that whatever happens will happen. But I'm very, very disappointed because I expect to have a very fair and understandable hearing. By the way, Mr. Campbell is as competent or qualified as anybody that works for the state of California in hydrology and mining and geology, has all the credentials up and down the road. He currently had been heavily involved in the Oroville Dam spill, and he's doing his work pro bono for us because he realizes that we could use the help. So I won't go into reading the different reasons why this is allowable under law. That's for other people to decide, not me right now, and take my time. I'm going to drift from what I wanted to start organizing myself with over this last few weeks. I did ask for an extension, and it was denied. But I'm really here today for two reasons. One is for enlightenment, and it's not only to enlighten the board, it's to help the staff. And we're in the process of enlightening the public about things like the Port of Cologne Act, the Basin Plan, the federal law, what it was really designed to do. The presentation for one of the arguments was beneficial use. I'll get into that. But the beneficial use, why I have the Allegheny Mining District, we're talking about a deposit that was formed about 130 million years ago. Mineral deposits and gold have elements in it. The beneficial use under the Port of Cologne Act was very, very specific to protect beneficial uses. It was passed in the 1970s, and the groups that put the effort in came from the private sector, the public sector, to try to do just what we wanted to do for California. I love my state. Our company has been here operating as a California corporation for over 107 years. The casual presentation, while I respect them very much, they're just doing their job. But someone needs to change the way the jobs are being performed. If we can't do it with your vote, I'm hoping that you will deny this. I think there's legitimate reasons for it, or else I'm asking you to postpone it so we can maybe have a little discussion. But those would be my wishes. But if that doesn't happen, I'm making a record. And I'll appeal it to the state like I did last time I was here. And the only way we can possibly do it, this isn't a threat. I don't want to be here doing this. I run a mine. And there are things that are wrong about the way this is being interpreted and presented to the public for many, many reasons. So the beneficial use was one thing that the legislators demanded that this law do. It wasn't, and right in line with that, when there's no dead fish, there's no acidic water. You saw a couple of slides. There, the creek is alive and well. I would drink the water out of the creek before I drink the water in probably any public building in my hometown of Sacramento. There's no aquatic insects that are dead. There's no vegetation that's suffering. You can see from a couple of the slides there that the Kanaka Creek is alive and well. Yes, there's a little more arsenic that comes in. That law was changed in what, 2006? It went from parts per million to parts per billion. There's some drinking, one of the bottled drinking waters has more parts per billion than our mine discharge. The uphill movement of water, I think one of you mentioned too, at some creek. We've had the Kanaka Creek flow back into the mine a couple of years ago. So I really got that one. The public outreach, that's why I'm here. I'm out here because I have family here. I've been here a long time. I have children and grandchildren. And the way that we're being treated right now is detrimental to the national security of our country, 300 million Americans and maybe 30 million Californians. Stakeholders, they're beyond imaginable. With our natural resources, with what's happening to rare earth minerals, California is a mineral-rich state. I gave a tour to 50. By the way, I'm testifying under oath. So everything I'm telling you, I want you to realize I back it up with my honesty and my integrity and the truth. I had 50 geologists from Nevada Geological Society last Saturday, gave them a tour of the mine. We talk about the need of natural resources. I talk to people about forest restoration. We're in the southwest part of Tahoe National Forest. We've talked about, we have 500 acres up there. We've talked for years about forest restoration, clearing the understory. Finally, it's coming in the Sacramento Bee and the different papers, and people are going, hey, that's something maybe we better consider. I'm here to give us all a heads up on what could happen to California with this mineral wealth. And that's to do and work on some of these situations where there's naturally occurring water. In 1998, we closed our mill down. We do not do anything to that water. We closed the mill to try to abate the problems that we were experiencing there about we were decanting our water and we were doing everything we could do. But we took that major step of stopping the mill. Sustainable. So far, and we also did a number of different tests. We put iron shavings because arsenic will adapt to iron shavings. What happened was the iron oxidized and it went into the creek water. So that didn't work too well. We did different things like that over the years. We've had experts come up there and try to do this. I was just given a card by one of their staff about Howard Hold saying maybe this guy can come and get a hold of you. We can work on a solution. Which is what I'm here to do too. And when you run a 107-year-old company, by the way, it's the oldest mining company in North America. It's the longest producing mine. It's produced over 1.5 million ounces of gold. We employ good, hardworking, blue-collar guys. We've been beat down to where we have only 6 people right now from a one-time of 60. And your organization, what you're here to do is just to protect the public and not just ratify the things that your staff says. In my notice, I think I said I spent 17 years in public service, chairing and sitting on groups like you sit on, and I knew the difference between trying to mitigate or come between the public, which we are, and the staff, the private. We are a publicly traded company too, I'm sorry. But the the government employees and the others. We really want some help from you guys. And if you help us and we do the job right, we can help all these other big financial companies that are going to come in here. The two major concerns that you could hang your hat on right now would be the Porter-Cologne Act and the definition of waste and the definition of navigable. We do not, what you was shown in those pictures, what your staff came up and not your staff, what our staff came up and did was they looked around and they saw certain things and they identified it as waste. It's not waste. The road to Allegheny was paved in the 1960s. Underneath was the rock from the 16-to-1 mine that grabbed the ground base. There's no evidence of any harm from this mineralized area that's up there. So if number one, it's not waste, it doesn't even meet the definition of waste. When you really look up the word, and the other one is navigable. Kanaka Creek is an intermittent stream. I mean, I've walked it. I've gone from the headwaters. We're up at the headwaters. It goes down a mile or so, and it's not navigable. And you can't pull a canoe. You can't pull a raft up it. You know, navigable was originally for ships, but what the American law did, they've put boats and rafts, and you can't get a boat up Kanaka Creek, and you can barely even walk up and down it. It's very, very steep canyon. It's very rocky, and it's a very intermittent flow. So I know others a lot. By the way, we're real small. We are real simple and small in the scheme of natural resources. But there's big guys out there, and most of them are global. Most of them are owned by multinational corporations. You guys should be proud, and sorry, ma'am, but I just say guys, and that you've got somebody in this state that is doing what the 16-to-1 is doing, and that's trying to work out an issue and work it out so everybody that comes along, similar to what you were doing with the fracking or with the water. I didn't quite hear all of that, but there's nothing out there ready in the woods jumping at the door to get our minerals, but I'll tell you, they're coming. They're coming. And it would be far better to develop some sensible things before these very, very wealthy people get in here or wealthy companies get in here and just work everybody over. I don't want to see that happen either. So you've got while the MMPs, there are some exceptions, and you have to read them and you have to see what they are. You could make that decision, and you could be very bold. You could be, back to that word, how about this, conservative progressivism. That would work really well with me. And take a stand of coming in and let the other people prove something that's not true. Those are some of your choices, but you can hang your hat on the legality that waste and navigable, which are required in determining these amounts of naturally occurring elements in the earth. On the this is a SEPA priority pollutant list. By the way, I got a lot of this off your website. Arsenic is one, of course. So's zinc, and so's selenium. I was thinking coming down here in 1967, a lot of the people that are working in this room right now getting paid for their jobs and doing whatever jobs they're doing weren't even born. And the country was having problems. The Cayuga River in Ohio was on fire. I went to Cleveland. I visited some in-laws. There were up in the Washington, the pollutants. It was a big problem for pollutant industry going into our streams and rivers. By the way, I was on the side at that time to object to that and help them all of that. That's not the case anymore. And the people that put this together put rules out and things, and it's time to realize that this is the 21st century. And it seemed to me that the problem with the E. coli, by the way, there's none up in ours that's ever come out. And we have mountain lions. They take their deer down sometimes by the creek to kill them. We have bears, and we have a load of deer. But there's no E. coli. And I learned today that a lot of it's coming from humans in the American River. That could be a real problem. There's nothing we can do about the natural occurrence of minerals in a mineralized area. We could sit there and we could try to fool everybody and put a little bit of something that would gather and attract the minerals, but it's not sustainable. That's the other thing you want, is sustainability. What we want to do is going to be sustainable. It can't demand high energy costs. Our PG&E bill sometimes runs between $5,000 and $10,000 a month. Oh, I know what I wanted to mention. I am qualified as an expert witness in mining in court. I do not have the same credentials as Rob Campbell, but I've worked on 2 state parks in the mines on contractors. I'm a general engineering contractor. And we opened up the mines and we did water work. I'm really familiar with water. And water, to me, is the most natural force on Earth, more so than anything. And it gets its way. It'll get its way over time. Remember, I'm dealing in an environment that was formed 132 million years ago. Of course, we've had a lot of changes since then, the last 1 million or 2 million years. But the situation is this is the kind of talk I want to hear somebody say, so these guys over there can do their job and feel good about it, so that group can do their job and feel good about it, and the people that are maybe sitting out there can do their job and feel good about it. By the way, I invited every one of you in my letter prior, when the due date to get it in, to come up for a tour. I would have given you a one-on-one. You could see whatever it is. You'd see that this is minuscule in the scheme of things. The fact that we've taken so much time on something that has been natural in the earth is a difficult thing to just swallow. By the way, there is toxic material coming out on the Sierra County. Their diesel tanks failed and dripped into one of our tunnels. They got a grant. I showed the water board. They haven't fixed it. But when we backfilled, we had to remove a lot of the. Remember, I'm telling you things I can prove. Everything I'm saying here, I can prove. It's all evidence. When they dug their hole and removed the toxic rocks, guess what they filled it with? Our mill sands, our leftover mill sands. It passed Caltrans. It passed everything. It passed all the inspections. They filled the whole hole with this alleged or thought about toxic material. This is the earth. This is the same rocks. They just came out. And so when one of the reports said that mill sand, I think it was fine sand was seen below someplace below the riprap, by the way. The rocks that were on the bank were riprap, so the bank wouldn't erode, of native rock that you can still see up there. And that sand that was just the fine sand is the same sand that passed Caltrans inspection. So it's not harmful. My point, I'm not used to this, going against a clock like this. There's zero impact. Oh, there's no red flags. Somebody remarked about red flags. Someone said, on the other things I listened to this morning, minimal impact is stated. That person wanted you to approve whatever he did with minimal impact. We have zero impact. It's not even minimal. It's zero. There's something out there that was in the 2017 federal tax law called, one of the things got in there called Opportunity Zone. It's not getting enough press. It's the most wonderful thing I think the feds have probably passed in my memory to try to bring investment capital into these depressed areas. Sierra County qualified. It has low income, it has lax housing, and it's one of 800 spots where financial money and plans can get together and try to make some positive improvements. It was sponsored by Senator Scott of South Carolina. I've written Dianne Feinstein and Kamala Harris, and I haven't heard back from them, but it'd be nice because it's a wonderful thing. It will help going into some of these areas. I know you're concerned about quality of life, and I know so many things that I've listened to these meetings over, and I know your intentions are pure and honest. But now I want to mention something that isn't pure and honest. I'm concerned about violations of the RICO Act. And by the way, the investigation has already started. And there's proof in the evidence in the book that's submitted that there, unknowingly perhaps, there's some contribution of some employees into possible RICO infractions. That means that helping someone else get an advantage over our company. There's a Silicon Valley billionaire. His name is Carl Berg, multi-billionaire. He's trying to bankrupt our company. He's in conversations with the Water Board and he's also contacted MSHA, or other regulatory people. He's called the workers' comp people. God, I don't know. He's called everybody. They're undermining our company. And I know from watching all of you in this room that there's a force and power and energy that is not in this room that could be directing some of your moves. And if that's true, I want to find out who they are, because they are hurting a well-established California corporation. By the way, California Sesquicentennial. Guess what was the only company that went through all the steps and rigmaroles to become a California Sesquicentennial joiner? That was us. I think there's enough to do what. Here's what I'd like you to do. I would like, of course, you to ask any questions you want, which you will. But I would like you to, first of all, deny these, but I doubt you'll be able to do that. But you could. You really could, because this violation of the Port of Cologne. Port of Cologne puts a lot of standards out there of what we in the sector out there are supposed to do. Depends whether you want to take that step or not. The other one, I'd like you to just maybe send it back to staff. I wish we had a little more time with staff. We worked with, we got a chance to work with Jim Marshall, and by the way, he came up, and then your staff came up. It was really good. I'd invite all of you to come up and really see the puny little amount of water that's going out of that mine that's really surface water that drips through all the cracks. It's been doing it for a million years, and drips out there, and it runs out this tunnel called the 21 that was put in 1865. So, and by the way, you talk about economic advantage, we're getting economically disadvantaged. You want to talk about something else? There's nobody, we've been singled out because we're playing it above board. We do the testing, we've been doing it for years, we get the results in there. We don't fake it, you know? But there's probably 100 or more mines, or not mines, water discharges in the Sierra that are doing more or the same amount. I can't even qualify that. But you go through the records and you won't find a lot of situations like we found ourselves in. And I see my time is up. I hardly began. Thank you very much.
Questions?
Oh.
Thank you, sir. Before you leave, is there any time left on the clock? I can't see it from here.
25 minutes.
He has used his time. There is some time remaining for the prosecution team.
Well,
For the prosecution team,
I got a question for him.
he's run out of time. Yeah, go ahead and ask your question.
Oh,
And then I'll give him some time if he wants that to cross the
I'm
prosecution
sorry. I
team.
got that confused. I'm sorry, I screwed up.
Never mind.
So we've identified a problem that is a violation of the rules. Can you tell me specifically what you're going to do to fix it so you don't have exceedances in the future?
Well, I thought of the idea again of a solar pump. First of all, it has to work. This is a really treacherous area to get down. You know, we missed some when the snow, I mean, ask them. This is really a treacherous place to get to, down to the 21 tunnel. I would prefer to set up a solar panel and run a pump so it doesn't take a lot of maintenance, and then pump the water up and spread it on the ground. Now, I know that was tried in Reading. I think that guy went to jail or something because they had toxic materials. We don't have anything toxic. That is one. But my preference on this particular site, that's all we're talking about. We're not talking about the rest of California or the rest of mines, because the deposit there is world famous, but it's so unique. I would probably petition the board that it would be a violation of the environmental law if I took arsenic out of the water that's been supporting a life of vegetation, fish, and insects for over 100,000 years. Because I know it's a violation to put something in, but I would be prepared to try to say that it's just as wrong if something's been there, because it's nature we're talking about. If we take it out, has anybody done a study on what that would be? The other thing is we never got the dilution factor. We had a plan. We went all the way down Kanaka Creek. And if you took anything at the point of discharge, it's going to be higher. We were not granted a dilution factor. You get a mile down the creek before it even gets to the Yuba or anything else, Bullard's Bar, and it's back to the same level. So it isn't, and it's nothing that we create. We do not add anything to that water. It's the same water that's running around all over, above, even above the site of the discharge of this 21 tunnel. So I think it would be scientifically, I know some of you talked about science, and I love science myself, and I think that's a ruling factor. I think under these conditions, there's no harm, no danger, and I don't see another way other than doing what I just mentioned about a solar panel and pumping it up there. But then somebody might say, you know, whatever we do, I hope we can do it in the longevity time, because when some of us are gone, the world will be run by different people. And when I said enlightenment, there's a lot of ignorance that I've heard and I've seen about what's going on at this particular site and what's going on with our natural resources. So with all your staff, I've heard you had staff, this is what I appreciate too. The prosecution team are doing their job. They're there to prosecute. I hate that name though. I mean, it sounds awful, and it wasn't always there. But solutions are what we're after, solutions. And I was just given a card that person may have a solution. So if nothing else, give us a little more time. We've made dramatic steps. By the way, I have 1,700 owners of this company, and we have families. We do so many different things. We can fix it. We're fixers. We can fix stuff, and maybe that would be an approach, because everybody else gets a dilution factor, and so that's. I think that we were on when Jim Marshall was up there. We did exactly what he wanted to do. I did it. I went down at different places where I could go down Kanaka Creek and took samples, sent them in, and then we put a map in, but we didn't put, the GPS coordinates. So we got all that done. We got all done, and then nothing happened. But we had a brief moment to talk, Mr. Marshall and I, and I said, boy, let's see if we can do something here. And also, we're poor. You know, we that's the economic. I didn't even raise that issue, but you look at our balance sheets. We report to the SEC, so you can read all our financials. We're very transparent.
Sir, are there any further questions? Excuse me. Do you have any questions you want to ask of the prosecution team?
Actually, I did. I did. I can be as brief as possible, I
Yes,
guess.
if they would come up forward so you can ask them questions.
Dr. Longley, I have a question.
Yes,
Can I ask Patrick a question?
sure, go ahead.
Patrick, sorry. So I have a question about the mining activity. To control the waste discharge, make sure it's not in exceedances, what measures should he be taking?
Yeah, and so we don't prescribe the manner of compliance, but that said, I think this was a topic that was discussed fairly extensively when the regional board adopted the time schedule order that gave 16-1 a large degree of latitude in terms of complying with water quality objectives. So, I can get into this probably in our in deliberations, but the water quality standards are for arsenic, I think, is 10 micrograms per liter. His 16-1's interim limit is 1,000, and it's that limit that we're blowing past. And so during the discussion of the time schedule, so it's I mean, you can't drink that water. I don't know of any bottled water. I know Mr. Miller said that there's bottled water, but I don't know any bottled water serving to their customers that over 100 times.
Could we do this during
those limits.
deliberation?
Absolutely. I think that was
Right.
discussed during the time schedule order.
And we can come back to that later. Mr. Miller, do you have specific questions for the prosecution team?
I can't find my notes on them, but I'll try to remember. Did any of you that have been to the site, or I know one. Has there been any complaints of complaints from beneficial users downstream?
Not that I'm aware of it.
Damn it. What were they? Did you see any dead insects, fish, or vegetation at the portal? Or has any been reported?
I didn't see any when I was there. However, I really wasn't looking for that. We were observing the sampling.
Okay. I'm not going to do this. Your staff
Okay.
did fine. There's no damage. I've made my statements.
Very
The
good.
creek is alive. I like these people.
Very good. Then we have, next on line is cross-examination of Mr. Miller by the prosecution team, if you have questions.
We don't have any.
Thank you. Mr. Miller? I give you just a couple minutes, please, for a closing statement.
Oh, my closing.
And first of all, stay right there. Do we have any I have no cards. Do we have any interested persons that want to testify on this matter? Seeing none, go ahead with your closing statement.
I'm going to make it really simple. I want your help. We're not the bad guys, and we're not polluting. And I run a company that's been in business for 107 years. The same company is very unusual. Mining has been going on there since 1860s. There's no sign of any degradation. The company, our operation, doesn't do anything to the water. We don't. Everything I've read about this is about all of this reasoning going way back was for industrial waste. This is just like rainwater and snow that filters through the cracks and reaches the lowest point and happens to run out in an old tunnel we had that was put in 1865. And the last thing I'd like to say, closing, is that the California water concerns. There are also other agencies that have concerns, and the federal MSHOG people have great concerns about berms on your road and things like that. So we're so clean. We've been clean and green. We don't use mercury, but we have to use that rock to put berms up to the axle size of our largest piece of equipment, which would be a 966 cat loader, and so we use that rock. We sell that rock to people in Sierra County, and this is what they're calling waste. It's not waste. So it's just been mischaracterized, which I can fully understand. But those, you got it. I'm going. Thank you.
Thank you, sir. Closing statement by the prosecution team.
Dr. Longley,
Yeah.
and Andrew Eltzvogt, Assistant Executive Officer of the Board. I don't have a closing statement other than I recommend the Board adopt the order as proposed. Thank you.
Very good. Thank you very much. This time we'll close the hearing, and discussion will be limited to board members and members of the advisory team. So let's continue to pursue your question.
And my other concern is this. What happens tomorrow? What happens next month? And excuse my lack of knowledge on mining and how that all works, but I'm assuming certain trade associations have best practices they put in, just like we talk with the folks with ag and oil, and we look for ways to mitigate issues that prevent degradation of water quality. So my concern is Mr. I'm sorry, I forget his last name. Understand that these options are out there, or at least he's made aware of them.
Yeah. No, if I could, can I ask for slide 18 from the presentation we put up? I think that's kind of informative with what's going on at the mine site, and I think Adam can talk a little bit more about the technology, but my personal sense is I was somewhat dismayed by the fact that there isn't a plan to do anything with the water. I think on a certain level, Mr. Miller's right. He doesn't do much to the water, but that's the crux of the issue here. He mentioned the burning of the Cuyahoga River, burned many times actually, but it was kind of one of the catalysts for the 1972 amendments to the Clean Water Act, which gave us the Clean Water Act we have right now. The fact of the matter is that the Clean Water Act imposes requirements on the end of pipe discharge, because the 1948 law that it superseded didn't put those end of pipe limits on. It essentially did what, you look at the river and you try and figure out what's causing the problem, and sometimes you can work back and figure out what the problem is, and sometimes you can't. And that was resulting in a situation where there's widespread contamination of the nation's waterways. The way the federal government decided to fix that was the 72 amendments, which put limits at the end of the pipe. The limits to protect water quality for Mr. Miller's facility are in that WDR's limit category right here. So if you look on column number 1, the arsenic, micrograms per liter, 20. That's the protective limit for water quality. Time schedule order, which the board adopted to essentially give Mr. Miller time to work on his solution. We did that a number of years ago. There's some solutions that have, a little treatment plant that you put up there. Some have passive treatment that doesn't even require power. There's a bunch of different ways that you can treat that arsenic to make it comply with water quality standards. And what you have in the measured category over here, 1308, that is extraordinarily higher than the standard that is necessary to protect human health. And that was kind of my comment made that Mr. Miller said that there are bottled drinking water that exceeds that. That would be poisoning people if it reached that level. I don't think that there's any drinking water provider there that that would provide drinking water to persons at 1,308 micrograms per liter when the standard is much, much lower than that. So that's a situation that we're in right now. He has a permit, and the permit requires end-of-pipe limitations that are not being met. The board adopted a time schedule order that essentially gives him time to figure out what solution he's going to be. We set the limits in that order, and the board has the prerogative to set those interim limits very, very high. The board did that and set those limits very, very high. Though even those limits are being exceeded. That's what's leading to the penalties here today. And the fact that Mr. Miller doesn't have a plan on what he's going to do to treat this water is extraordinarily concerning to me, because that time schedule will run out. There is a clock ticking every day that issue isn't being addressed. And when that time schedule runs out by statute, we don't have any room to debate about what needs to be done. When the time's up, the time's up, and that 20 limit kicks into effect, and you have very, very serious water quality concerns in that area. I will say that he's right in that there is a lot of mineralized activity where he's operating. There's a lot of abandoned mines, in all likelihood, where he's operating that are also contributing water quality problems. Those are compliance issues too. But if you accept the burden of getting a permit from the regional board, if you accept the burden of operating a facility in the state of California that discharges to a navigable water or a tributary thereto, you have to have the obligation to comply with limits that are protective of water quality. Those limits are being blown past, and even the interim limits that are set much, much higher are being exceeded. And that's very concerning. That's really why we're here today. My recommendation is to adopt the mandatory minimum penalties as proposed, and to continue to monitor this and to continue to demand that Mr. Miller take the appropriate action to make sure that his facility complies with water quality standards.
May I say something, please?
Closed, sir. The meeting's closed. Just discussion between our advisory team and board members.
I think the minimum penalty might not be enough. What's the maximum penalty we can do right now?
Yeah, I think today, the way this is teed up, and it's teed up just as a matter for mandatory minimum penalties. If you kind of direct the board to keep an eye on this one, the prosecution staff will assess that and potentially bring an enforcement action back to you for separate action at a different day. But this is, what we have in front of us today. I wouldn't recommend going higher than the mandatory minimum, because that's kind of that's essentially how the thing was charged.
Any further discussion?
I love abandoned mines. Not really. It's incredibly complex, and it's a very difficult, intractable issue in some cases. This is kind of one of those, and we talked briefly this morning about the Iron Mountain mine, and the motto that the staff up there uses are mines are forever. I don't know what the flow is on this, what the variability of this flow is through the summer and through the winter. I think we need flow measurements too.
We do get flow measurements. Off the top of my head, I don't know the variability of the flow.
Yeah, I think, I'm not a mining engineer. I can't figure out the solution to this problem. I'm not sure there is one, but, you have to make efforts, and there needs to be some work done on identifying those and move from there. But, infiltration trenches, and actually the comment that Mr. Williams made about discharge to land and infiltration and evaporation of water may be a possible solution, although arsenic makes it a question. I don't know how you remove it, but so yeah, in answer to the question of, I would hope we'd be working on a plan. There isn't much time. What happens at the end of the time schedule ordinance? Hard questions, yeah. But I will say, and I'll make the motion, that, this is the minimum mandatory penalty. We've talked about how that locks this board in some cases. This might be one of those cases, but we're still locked in. And basically, we need to approve this as our action, as recommended by staff.
So
Sorry for the rambling.
one thing I will say is in one of their exhibits, Mr. Miller's exhibits, Exhibit 5, there is a work plan that was put together by a consultant to try and treat some of the arsenic and antimony in the effluent. And that's right, the Geosolve. They did some, I wouldn't call them pilot scale, I'd call them lab bench scale analyses. Right, and it seems like the results there, if they did the work correctly, are showing some pretty good removal of arsenic. They go from around 230 in the pre-treatment to around 15 in the post, which is a lot closer to where we want to be. And our staff have been out there to talk about potential dilution. I don't see dilution when they're up at 700-800, but if these treatment alternatives were to work, a dilution at a lower level like that could be possible.
So do I take what you just said, Bob, to be a motion? Yes. Have a motion. Do I have a second?
Second.
Bob, I have both a motion and a second. Any further discussion? Bob made the motion, Raji seconded. No further discussion. Call the roll.
Mr. Schneider? Ms. Brower?
Yes.
Dr. Markham?
Aye.
Dr. Longley?
Aye.
Motion carries.
Thank you very much. We'll take be back here 15 minutes, please. We're in recess. You're right, Bob. Oh, here we go. No?
Let's get your stuff up on the.
I did find some slow. care of the audience, maybe, depending upon who's here. Before we proceed, how many folks are here for the L&D landfill? Okay, we've got more folks here for that. If you don't mind, we do the information item last.
It is at your pleasure, Dr. Longley.
Okay, good. Sorry, Jim. I know you're all set up. The board then will move to agenda item 21. L&D Landfill and Fruit Ridge Road Land Company, Sacramento County. This is the time and place for a hearing to consider waste discharge requirements for L&D Landfill in Sacramento County. This hearing will be conducted in accordance with the notice of public hearing and the meeting procedures published with the meeting agenda. At this time, evidence should be introduced on whether the proposed action should be taken. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer, I do. The dischargers are L&D Landfill and Fruit Ridge Road Land Company. The total times allowed for testimony: L&D Landfill, 10 minutes. Rosemont Advocates for a Clean and Safe Environment, 10 minutes. All other persons are interested persons and shall limit their testimony to 3 minutes, and a timer will be used. Now, please state your name, address, affiliation, and whether you've taken the oath before testifying. And let me restate that. Please tell us whether or not you've taken the oath before you testify. Does council have any legal issues to discuss at this time?
Dr. Longley, Rosemont Advocates has requested that certain materials be distributed. All of the materials that were sent to staff and council have been approved for distribution and are now being distributed in hard copy for you right now. And no other legal issues.
Thank you.
Yes, I'll make sure. We'll make sure that if there's no extra copies, we'll make a quick photocopy and get it over to them.
I think we should have extra copies.
Just for the record, these are the individual letters that were sent to the regional board and the correspondences.
Thank you.
We need to welcome our additional board member.
Yeah, she's busy this morning speaking. She had a speaking engagement, is my understanding. Okay. You going to give that to Tess?
We're going to run off an extra copy, I think, if we don't have an extra one.
Well, she needs one right now.
I know.
Thank you. We'll now begin with staff presentation.
Good afternoon, Chairman Longley and members of the board. My name is Brad Shelton. I'm the Senior Engineering Geologist in charge of the Title 27 Permitting Unit here in the Sacramento office, and I have taken the oath. I'm here today to present the proposed revised waste discharge requirements for L&D Landfill. The proposed order is being contested by Rosemont Advocates for a Clean, Safe Environment, also known as RACE, and they have also prepared a presentation. The discharger is not contesting the order, but is in attendance and available to answer questions. L&D Landfill is located in the city of Sacramento, approximately 7 miles east of downtown, 2.5 miles south of the American River, at an elevation of approximately 45 feet mean sea level. The site's bordered by Watt Avenue to the east, Fruit Ridge Road to the south, rail lines to the west. Landfill 1, also known as LF1, is an unlined waste management unit that's been in operation since the 1970s. Landfill 2, also known as LF2, is a compositely lined waste management unit constructed in 1996. The liner system at LF2 includes, from top to bottom, an operations layer, a filter layer, a leachate collection system gravel, a high-density polyethylene membrane, and a geosynthetic clay liner. As with many landfill units in the Central Valley, both were constructed in former gravel quarries. A landfill gas extraction has been in operation at the site since the early 1990s and was expanded in 2005 and 2007. The landfill gas extraction wells are shown in this slide in red. Perimeter landfill gas extraction is primarily used for methane recovery, while the internal landfill gas extraction wells are used intermittently to address volatile organic compounds in the vapor phase. Before we look at the details of each landfill unit at the facility, let's look at how some different waste terms are defined in Title 27. Construction and demolition wastes are non-hazardous wastes that include building materials, rubble resulting from construction, remodeling, repair, and demolition operations on pavement, houses, commercial buildings, and other structures. Commercial solid wastes include all types of solid waste generated by stores, offices, and other commercial sources, excluding residences and excluding industrial wastes. Title 27 refers to Subtitle D of RCRA for a definition of municipal solid waste, where it defines a municipal solid waste landfill as an area of land or an excavation that receives household waste. Subtitle D then goes on to define household waste as any solid waste, including garbage, trash, sanitary waste, and septic tanks, derived from households. Putrescible wastes include wastes that are capable of being decomposed by microorganisms with sufficient rapidity as to cause nuisances because of odors, gas, or other offensive conditions. Now that we've covered types of waste, let's talk about the individual waste management units at the facility. LF1 operated from 1976 to 1995, reaching an interim grade of approximately 30 feet above mean sea level, after which it was used as a soil stockpile area while LF2 was being filled. In 2016, waste discharge to LF1 resumed. As with many waste management units constructed prior to federal regulations, this unit is unlined. LF1 primarily accepts construction and demolition wastes and commercial wastes. Records indicate that LF1 accepted small amounts of miscellaneous waste that may have come from household sources throughout its history. Therefore, the WDRs treat the landfill as a municipal solid waste landfill, even though it no longer accepts municipal solid waste. LF2 began operation in 1996. This waste management unit is lined with a composite liner with a leachate collection and recovery system. LF2's waste stream is very similar to LF1's, but it accepts about 20% household waste annually. The existing WDRs are being revised due to the discharger proposing an increase in the maximum allowed height of the facility. The proposed WDRs require several items to address issues at the site, including the following: an interim cover operations and maintenance plan and feasibility study with the goal to prevent or minimize infiltration or precipitation, an updated landfill gas and groundwater extraction system plan to prevent degradation of groundwater, and an updated slope stability analysis. The proposed WDRs also contain the following restrictions on the facility: a height restriction to 140 feet mean sea level, no discharge of municipal solid waste to LF1, and the proposed WDRs include a schedule for closure of the various phases of the facility, with the final closure occurring by the year 2031. The tentative WDRs were circulated for public comment for 30 days between January 22nd and February 21st of 2019. The notice of public hearing was sent to dischargers, CalRecycle, Department of Fish and Wildlife, State Water Resources Board, Sacramento County, the City of Sacramento, and the Sacramento Bee. Comments were received from the discharger and from RACE, a community group made up of residents in the Rosemont community located approximately 1 mile northeast of the facility. The tentative WDRs were originally scheduled to be heard at the April meeting of the Central Valley Water Board, but based on correspondence with the City of Sacramento regarding the status of their CEQA review, it did not appear that CEQA would be completed before the April board meeting. Therefore, the WDRs were removed from consideration at the April board meeting on March 6th. On March 14th, staff were notified that the city had adopted their negative declaration, but it was too late to include the item on the agenda. On May 3rd, a notice of public hearing and the responses to comments were sent to L&D Landfill and RACE. On May 15th, staff received a letter from RACE notifying of their intent to contest the tentative WDRs. Comments received from the discharger consisted mainly of clarifications and minor corrections to a variety of items, and no major changes were requested. Changes were made to the tentative WDRs to address their comments. Again, the discharger is not contesting the proposed order. RACE's initial comment letter received on February 21st included a total of 15 specific comments, all of which relate back to 4 central assertions. Number 1, that there was a lack of proper notification. Number 2, that LF1 is operating as a, quote, open dump that should not be expanded and should be closed. Number 3, the continued discharge of waste to LF1 is a violation of the anti-degradation policy. And 4, that the tentative WDRs do not comply with CEQA. RACE Central Comment Theme Number 1, lack of proper public notification. RACE contends that the notice of public hearing did not comply with Title 27, Section 21730, because it did not include the US EPA, the Rosemont Community Association, adjacent property owners, nearby well owners, or RACE. Title 27, Section 21730 addresses public participation requirements for any regional water quality control board proceeding related to land disposal of waste. Here's what Title 27, Section 21730 says. It states the following entities shall receive notice: the discharger and responsible public agencies, news media serving the county, as well as communities within 5 miles, citizens groups representing local residents, environmental organizations in affected counties, interested industrial organizations, and there are also requirements for any municipal solid waste landfill at which a release has migrated beyond the facility boundary. The notice of public hearing complied with the legal requirements in Title 27, including posting of the notice through electronic means. Our public notice process is designed to make potentially interested parties aware of upcoming items before the board. RACE was able to submit comments on the proposed WDRs and has been included in subsequent correspondence. In summary, our public notice was proper. RACE Central Comment Theme Number 2, LF1 is an open dump. RACE contends that the tentative WDRs continue to allow the unlined LF1 to operate as a, quote, open dump in violation of 40 CFR sections 257.3, 257.4, and 258.1 G through H because the federal deadline for closure or retrofitting with a composite liner has passed. An open dump is essentially a disposal site that does not comply with federal regulations regarding management of non-hazardous solid waste. RACE contends that because LF1 does not have a liner system, it does not comply with the regulations. This is not correct, as the liner requirements set forth in Part 258 only apply to new municipal solid waste landfills and lateral expansions. As long as LF1 is not expanded laterally, it will remain exempt from municipal solid waste landfill requirements. A vertical expansion is not a lateral expansion. Additionally, Part 257 is not applicable to municipal solid waste landfills. We are making sure all applicable regulatory requirements are being addressed, but LF1 is not a, quote, open dump under US EPA Subtitle D regulations and is not required to close under some sort of federal deadline. RACE Central Comment Theme Number 3, Anti-Degradation Policy. RACE contends that because LF1 lacks a containment system, it should be closed, and the tentative WDRs do not adequately address compliance with the anti-degradation policy. In considering compliance with the anti-degradation policy, many things are examined. The proposed WDRs require updated landfill gas and interim cover plans that will prevent groundwater degradation. Ongoing corrective action is addressing impacts to groundwater. And the proposed WDRs do not allow municipal solid waste to be discharged to LF1, and neither unit can accept putrescible wastes. The Water Board is allowed to factor in all these considerations when assessing compliance with the anti-degradation policy. This proposed order complies with the anti-degradation policy because they do not authorize degradation of groundwater. Additionally, requiring closure of the facility is inconsistent with the maximum benefit to the people of the state of California. RACE Central Comment Theme number 4, CEQA noncompliance. RACE contends that the City of Sacramento's negative declaration failed to account for the significant environmental effects associated with the vertical expansion, and that the proposed WDRs do not comply with the notice of determination, that no significant impacts to the environment will occur from the proposed vertical expansion. Central Valley Water Board staff was consulted as part of the city's environmental review process, and the issuance of revised WDRs was actually considered as part of the city's project. Accordingly, the Central Valley Water Board, as a responsible agency, is entitled to rely on the city's negative declaration. No separate environmental review is required. The tentative WDRs were revised to reflect subsequent events relevant to the Central Valley Water Board's compliance with CEQA as a responsible agency. At the end of the day, this is not a unique facility. There are other active, unlined landfills within the state of California, some of which continue to accept municipal solid waste. To the extent that this facility will only be accepting a small amount of self-haul waste, which could be considered municipal solid waste under certain contexts, such waste will only be disposed of to the line unit, but no garbage or putrescible waste is allowed to be discharged to either unit. The primary waste stream will be construction and demolition and commercial waste. Federal regulations do not prohibit the vertical expansion of unlined municipal solid waste landfills. The requirements of these WDRs, including landfill gas extraction and implementation of plans to minimize infiltration of precipitation during the rainy season to reduce possible leachate generation, will continue to effectively address potential impacts to water quality. This concludes our presentation of the proposed WDRs for L&D landfill. We recommend the board adopt the revised permit as proposed. I would like to enter the case file and this presentation into the record. We're now prepared to answer any of your questions. Thank you.
Board member questions?
Yeah, after the vertical expansion, when it reaches a limit, then what happens?
Well, there are requirements for slope stability that are generally going to require how tall this landfill can get. They have benches that are required due to design standards. So the plan is in the WDRs, there's a phased closure by 2031. Does that answer your question?
Well, then after 2031, it just sits there?
No, it's closed. It'll be a closed landfill. It'll have a final cover.
Will we be requiring any monitoring after that?
Yeah, generally speaking, you have to monitor the landfill until it's no longer a threat to water quality.
Okay, thank you.
Any further questions? Thank you, sir.
Thank you.
Very good presentation. At this point, Rosemont L&D landfill, excuse me. Getting ahead of myself here. And Tess, you're going to have to turn it on.
Yeah, it's the 06/06/2019. And actually, before our time starts, Chair Longley, I do have a legal issue I want to bring forward.
So first, I will introduce myself, Tess Dunham with Somac Simmons & Dunn, here today on behalf of L&D Landfill. I do have some objections to a couple of the exhibits that were distributed. These are exhibits that should not be within the administrative record. They came in after the final written comment period expired. And so in particular, exhibits 1, 3, and 4. And in fact, exhibit 4 was issued yesterday. So we find that these are written comments that, you know, whether they were sent to other agencies or not, they are improperly distributed and should not be included as part of the administrative record.
Counsel, I need advice. Counsel is counsel.
Okay. So I suppose we're asking for, Tess is asking for a ruling on a series of documents that were distributed to you. I don't know if you've read them yet. The issue is that they were received after the formal comment deadline. You know, but I'll hang on for 1 second. I'll have a recommendation on that. Yeah, no, the recommendation is any that came in after that you not consider those matters. Anything received after the formal comment deadline, which was what date?
Formal comment deadline was the
February, I believe.
February 21?
21st, yes.
February 21 would not be entered into the record.
And I have not looked at them, so finally.
We'll put those aside.
So we just set them aside, don't read them.
Set them aside and don't read them. Appreciate that, bringing that to our attention.
Thank you. So we'll get started here. Again, Tess Dunham with Somac Simmons & Dunn here today on behalf of L&D Landfill. And I did take the oath, although I don't think I'm required. I'm not providing testimony or evidence, but you know,
you cooperate.
I try to cooperate, Chair Longley, as much as I can. Also with me today, I have the folks from L&D Landfill. I have Mike and Tim Lean, as well as our consultant, Mr. Pat Sullivan, and Jeff Mills from L&D Landfill as well. So if you start asking any technical questions, I got backup. So you don't have to listen to me try to talk technical stuff, because I know that doesn't always work out so well. So I'm going to go ahead and get started. We just have a few comments we want to make here as an overview, and then we actually would like to preserve 5 minutes as a rebuttal time. So moving forward, just to give you a quick overview of our operation, we are a long-time established operation, and we really primarily accept construction and demolition waste and non-hazardous inert waste. I think also most importantly, I don't have it here in the overview, but we are more than just a landfill. We are actually more of a recycling facility, and in fact, we recycle more than 50 to 55% of the waste that comes into our facility. We're very proud of our recycling efforts and what we do. We have a line that we sort through all the materials so it can be recycled as much as possible. We also we sell a lot of the recycled concrete to Caltrans that meets the specifications for their asphalt base. We recycle wood, green waste, cardboard, you name it. So we a lot of our waste does not actually make it into the landfill that comes in. We do recycle. So we also would want to just comment that there are some substantive new requirements within the revised waste discharge requirements that are pretty onerous. They're going to be difficult for us to meet. They're going to be expensive for us to implement, but we are not contesting those requirements here today. And we ask that you do adopt the order, but there is one revision we are going to ask. We would consider it a minor revision, and it's a date change for one of our reports. And I'll explain why we feel that's necessary. But first, just to explain a little bit, since we are not your typical landfill in that, while we do have the normal consumer may come in with a truck, that is not the majority of our business. The majority of our customers are the construction drop box haulers and professional contractors. The small amount of small loads that do come in, we only accept if it's household furniture, backyard waste, or wooden construction materials. As L&D says, it might come out of your garage or your backyard, but if it's from the inside of the house, unless it's furniture, we won't accept it. So just to make sure you understand and appreciate the difference between our landfill and more of a typical landfill that we're all used to. Also, this is just a quick overview of the percentage of waste that we do accept at L&D, so you have an idea. As you can see, the construction and demolition debris waste is almost a majority of the waste that came in, as averaged over 2014 through 2017, followed with concrete, dirt, and asphalt, and then the percentages follow from there, just again to give you an idea of the type of waste that's coming into our landfill versus others. We do not accept, and it is prohibited in the tentative DRs, but we do not accept petrucible waste, household waste, hazardous waste, liquid or semi-liquid waste, treated wood, or any designated waste. And I was just really excited I could pronounce petrucible. The requested revision that we're asking for is in provision G6B of the order. There are requirements for an investigative and groundwater model work plans that are required to be submitted on August 31st. And then the results of that investigative work need to be submitted by November 30th. We are concerned that, including the groundwater modeling results, we actually need the information from the investigative work that's due November 30th in order to do our groundwater model. And so having our model results due at the same time as the data and information would be using for our ground model makes it difficult for us. So the only change we are asking from you today is to extend out for the groundwater model results only. None of those other report provisions extend that out to January 31st, 2020. So with that, we'd like to reserve the remaining of our time in order to respond to any comments if necessary after listening to the other interested party. And we would then ask that you adopt the WDR with our requested revision. And we are here to answer any questions that you may have. Thank you.
We may have questions for you, Tess. So if you could just stay there, I'd like to ask staff about the requested revision.
This is Rob Busby. I'm taking the oath, supervising engineer and geologist. We're fine with the extension.
Very good. Thank you.
Thank you.
Any board member questions for Tess Denham?
Yeah, I've got one. How did you arrive at the height? The height of the ultimate?
This is where I get to call a friend.
Bring on the friend.
Mike Lean is the general manager, and he's going to come up and help answer that question.
Good afternoon, Board. Mike Lean, L&D Landfill. My address is P.O. Box 255009, Sacramento 95865. And I have taken the oath, and I think that's
it.
Everything you want me to say? Okay. The height of 140 was determined by the taking a 10% slope, which is an existing slope we have at the landfill today, and this was studied in terms of the slope stability that was mentioned earlier, and that slope, if you take the existing 10% that we have, where we shift from 10 to 3, we go 10 all the way up, and that's how we determined the 140.
Any further questions? Thank you, sir. Next, we'll take testimony from Rosemont Advocates for a Clean and Safe Environment.
you'd give me a second or two to gather myself. Okay, my name is Vanu Jain. I'm a licensed engineer in the state of California, license M30801. My mailing address is P.O. Box 2814, Rancho Cordova 95741, and I've taken the oath. My wife and I have been residents of Rosemont for over 30 years. If you look at this map here, the Rosemont community is outlined by this black line. And the down in the lower left, that's where L&D landfill is located. Why are we here today? There's someone who said, the wisdom of a generation is vindicated by the actions of its children. Waste disposal practices in the 1970s and 80s were basically find a hole and fill it. Many landfills like L&D landfill were constructed in gravel pits which ceased operations due to encountering shallow groundwater. And if you drive around the Sacramento area, you'll notice a lot of gravel mining operations. And if you look at where the base of those mining operations are, they're typically at where the miner encounters groundwater, and it just doesn't become practical to dewater the land in order to get those gravels. So this practice continued, and then state and federal regulators determined that they were discovering contamination in groundwater. They determined that this practice could not continue. So they came up with regulations to require containment of waste. This is typical of point sources where we try to contain the waste. So today, what I would really ask is to determine whether your actions today will vindicate the wisdom of the water quality protection regulators who basically focused on waste containment. I want to just show you something that was in the tentative WDRs, how the landfill one, which is an unlined landfill, approximately 92 acres, was classified. Under Title 27, it was classified as a Class 3. Under Subtitle D, it was not classified. It's basically said it was not applicable. After race comments on the tentative WDRs, the WDRs were changed, and you'll notice that now landfill 1 is classified as an existing MSW landfill, municipal solid waste landfill under Subtitle D. But more importantly, I want to point your attention to the Title 27 classification, a Class 3 containment landfill. The containment system is a Class 3 containment system. And you'll notice down at the bottom, there's the adequacy of containment is based on citing factors, Title 27, Section 2260. So I just want to point out what Title 27, Section 260 says regarding Class 3 landfills. It bases its containment on a geological setting. And as you can see on the screen, there are several factors to determine whether the geologic setting provides adequate containment. Now, you'll notice that in the language, it'll say that in Part 2, B2, it'll say, where consideration of these factors in B1 indicates that site characteristics alone do not ensure protection of quality of groundwater or surface water, Class 3 landfills shall be required to have a single clay liner with a hydraulic conductivity of 1 × 10 to the minus 6 centimeters per second or less. This liner does not have engineered liner as a containment system. The question I'd like to ask is, do the site characteristics alone at L&D landfill ensure protection of quality of groundwater and surface water? I would pose this question to any professional geologist or certified engineering geologist to certify under oath that these that L&D landfill meets these requirements for the protection of groundwater quality and therefore does not need a liner. Okay, so I don't know if there's anyone here that would be willing to stand up and make that certification, because if they were, the next question I would ask is, why are you having the discharger do a groundwater pump and treat or groundwater extraction and treatment system, their GET system, if the waste is being contained by the natural geologic materials? So RACE would request that the finding 3 be updated to properly classify landfill 1 as an unclassified unit. It cannot be classified as a class 3 unit, and because it does not have the appropriate liner. Also, we would ask that the note 2 be stricken. The geologic setting alone does not provide adequate containment of municipal solid waste, and you'll notice that they changed the classification of this unlined landfill as an existing municipal solid waste landfill. And landfill 1 does not have a liner system. Pump and treat system is not containment. Once waste contacts water, there is no containment. Now you're doing cleanup and abatement. What is this meeting really about? Landfills only make money when they take waste, tipping fees. Landfills lose money after they are closed. So there's a balance here where you have to determine whether water quality protection for future generations is more important than L&D profits. They're proposing a 2.2 million cubic yard vertical expansion, and I just estimated at $10 a cubic yard, that's $22 million, not including cash sales. The bottom line is L&D landfill can afford to throw a bone or two towards the water board to make it feel like it's doing its job. Now I'd like to talk about this negative declaration because in the 2012 WDRs, there was a closure schedule, and the question that you had asked, the closure schedule set the maximum height of the landfill at 97 feet MSL. So we residents of Rosemont, we were looking forward to when this landfill would be closed, and that's depicted by line BEC on this graph right here. By 2023, we expected no daily throughput, no traffic, all the other impacts associated with an operating landfill. However, the city of Sacramento, which has an interest in this project, is shown by this table below, which basically sends 40% of the waste received by L&D comes from the city of Sacramento. They used a different curve to determine negative declaration. They considered that the landfill would continue to operate, and therefore, since it's continuing to operate, there would be no impacts. And that kind of makes sense if you have the delta change is 0 when you're basically following the same line of trajectory. Okay, regarding L&D landfill vertical expansion, this is taken out of the EPA technical manual that accompanies the EPA criteria for 40 CFR 258. And it talks about circumventing the regulations, and I don't have enough time to really go into this. But basically what it says, existing units can indeed be vertically expanded. However, vertical placement of waste over a closed unit would be cause of the unit being considered a new unit and would be subject to the unit design criteria. LF1 had been closed from 1995 to 2016. They call it an interim closure, but really it didn't take waste for 20 to 30 years. So I don't know if you would consider that a closure or not, but if it's not taking waste, I think there's things in Cal Recycle that say it needs to close. Regarding a lateral expansion, this is the devil's in the details, they say, and engineers do look at the details. So if you look at this cross-section of LF1, In 1995, they were at 30 feet MSL, which is below street grade. And this detail of the side slope shows relatively where they were to street grade. Now, if this side slope has any horizontal to vertical relationship, in order to come up to street height, you would have to expand laterally. I would ask, if possible, I could get an extra 5 minutes.
I'll grant you 5 minutes.
Thank you. Regarding minimal opportunity for public participation, this is a timeline of the events. So we submitted comments back in February of 2019, February 21st. The Water Board withdrew its WDRs, and I kept watching the website because in response to our comment about not properly noticing, the response to our comment was, we post things on the web. That's the way we notify interested parties and the public. So I kept watching when they would post when this WDR would be scheduled for a board meeting. And as of 12 May 2019, this is what it said, that the L&D landfill was proposed for consideration at a future board meeting. So as of less than a month ago, it was not clear whether or not this would go to the June board meeting. So if the public were to look at this, how would they even know whether to even attend this? Because it wasn't posted as soon as possible when it was going to be seen at a board meeting. Also, May 15th was the deadline to contest, which is 3 days after I checked the website. So how could anyone contest this if it hadn't been even posted on your website? Also, on June 4th, on June 15, when we contested, we asked about submitting materials. And on June 4th, Water Board staff enforced race that it needed to submit the materials by June 5th. So we did, and those were the things that were not accepted. And then also we were told that we had 10 minutes and we were not going to be able, our date was moved up from June 7th to June 6th.
On your previous slide, I noticed, though, that it did say the materials had to be in originally by 21 February 2019.
That's correct, but how would we know what to submit unless we got responses from our comments? How would we know whether or not those responses were adequate and whether we needed to submit more information? Anyways, moving on. So non-compliance with public participation requirements. There's several things in these WDRs that basically take the public participation out of the process and move it to a backroom situation. And I just noted I don't really have time to go into this. Miscellaneous, these are some things that the WDRs were concerned about. And one of these things about the anti-degradation that I highlighted, in the response to comments, the responder made this statement that what was being proposed is to the maximum benefit of the people of the state of California. This statement right here, just like with CEQA for overriding considerations, needs to be made by the board members within the WDRs, not outside of the WDRs. So in conclusion, Race would ask that you would vindicate the wisdom of those water quality protection regulations by not allowing this practice of waste disposal in unlined gravel pits at L&D to continue. Do not sacrifice water quality protection for future generations just because L&D landfill throws you a bone, making you feel like you're doing your job by having certain things that appear as if it's being regulated. Honor the CEQA negative declaration. The community residents in Rosemont, were expecting that this landfill were to be closed that 2023. That that thing that you had mentioned about a height limitation, the limitation was 97 feet, and there was actually a closure schedule based on a preliminary closure plan that was put in the WDRs. Now that has changed, and now it's been expanded to 2031, which under a negative declaration just doesn't seem possible. Finally, recognize that the tentative WDRs underwent significant changes. A 97-acre LF1, which was before not an MSW landfill, is now an existing MSW landfill. Also, there wasn't a GREL supply monitoring map in the WDRs when it was circulated under the tentative WDRs. That was incorporated afterwards. Changes to the corrective action removed required public participation. To be fair, if these WDRs to move forward, those significant changes warrant the WDRs to be recirculated for public comment. Race would like to thank you for your time. We would ask that this presentation be in transcript be entered into the public record. Race requests that the documents submitted to Water Board staff by email be included with this presentation. At this time, I would welcome any questions or comments.
Questions from board members?
Yeah, could you expand on the CEQA negative declaration and your interpretation of it?
Sure, I'd love to. Let me see if I can find it. Okay, so the city filed a negative declaration, and basically what they filed it on is assuming that this landfill, if you notice on the y-axis, is increasing environmental impacts. So this is just a cartoon to try to show you that as you go up the y-axis, there's increasing environmental impacts. So when the city did their negative declaration, they assumed that the landfill would follow this trajectory A, B, E, and F. Well, if it follows that trajectory, of course, there's not going to be any significant impacts because it's following a path that it was assumed to follow to begin with. However, your WDRs, the CalRecycle permit, and the conditional use permit for this land site had a trajectory A, B, E, C. And this is what the residents of Rosemont were expecting. So this area that's marked off in red, these are the realized impacts that we would experience if this landfill did not follow the trajectory that was in your permits, in the permits that were issued to it back in 2012. So to us, the negative, if you want to make that negative declaration valid, you need to follow the A, B, E, C trajectory, which basically says closure in 2023. And that's what was in the 2012 WDRs.
So real quick, did you challenge a negative declaration?
No. I'm accepting the negative declaration. I'm saying if it's truly a negative declaration, follow the trajectory that was the trajectory that it was the landfill was going to follow. I don't know if that makes any sense.
And I have a question to ask of the executive officer or one of your staff. The contention that this cartoon, as it was characterized, depicts environmental impacts. Do you feel this has validity, or?
It could. I mean, it sounds like it's more a question for the county, and that's why I asked if they, or the city, and that's why I asked if they challenged the negative declaration, because that's something that you'd want to bring up in the negative declaration, not in the waste discharge requirements that are adopted after the negative declaration.
And I would add that, you know, with regard to the negative declaration, the declaration is a descriptive of the project as approved and not a limitation on the project. That's so the negative declaration was basically the city saying yes, with the land use entitlements that are associated with the vertical expansion of this landfill All those things, if we change that, that will not have an effect on the environment. And then that is what they certified in certifying, or that is what they did in certifying that negative declaration under CEQA. They were not saying this landfill going forward, you know, if it does what we've allowed it to do, or notwithstanding whatever we've allowed it to do, cannot have an impact on the environment.
Yeah, furthermore, I don't see, you know, the way this is constructed, it shows there's really no values on the ordinance, and that becomes a bit dangerous when you're trying to make quantitative assumptions.
Yeah,
Well,
and I think it has some validity from, you know, from the
conceptually,
viewpoint of conceptually, yeah.
But it does not have a quantitative basis.
No.
It does. Actually, I beg to differ. It does have values on the y-axis. If you'll notice these boxes, it has daily throughput of 4,125 tons and traffic up to 480 vehicles a day. At point C,
But the relation of that to, you know, I'm a registered engineer too. I don't, quite frankly, I'd have to challenge you on that.
Well, hang on, Carl. I mean, the basic concept here, if I understand from a previous hearing, is that Sacramento has certified the environmental negative deck.
Right.
Therefore, we are bound by that decision, whether I agree with it or not.
Yeah, no, I mean, we rely on a prior agency's CEQA findings. That's how CEQA works.
Well, we're expected
We're
to.
bound, are we bound by that? So the discussion's mute is all I'm saying.
Yeah, I mean, I think in this case, the phrase would be we're entitled to rely upon it. And CEQA has a very strong presumption of not giving people two bites at the apple. And this project was approved at the county, the city. Conditional use permit was established, and then we adopted WDRs. Revisiting the CEQA every single time, that's not how the statute was set up.
And if I could just add, if you look at that chart, basically, if that, as Mr. Jane pointed out, that if the second point at point C, that would be basically daily throughput would be closure. Nothing's going in and out. Nothing more is being deposited there. And that's essentially, if you were to interpret that, basically, going back to my earlier point, that negative deck would basically, you know, as Race would want it to be interpreted, would be basically an order for closure, and that's not what the city was doing at all.
Well, I don't know if they had any overriding considerations or findings in their decisions, but basically you got what is happening here is there's 8 years of additional traffic and air quality impacts on the environment. That's, you know, but I think we're kind of locked in here. And we are not, it is our job at this point in time to argue the merits of the negative deck.
Wait, are we talking about an old CEQA document, or does there need to be a new one for the new date?
They adopted, what was the date of the neg deck?
The negative deck was originally published back in December of last year, and then it was, I believe, finalized or adopted in April. And you know, I mean, the idea would be, well, actually, there was an earlier question before that. What was it? I forget who asked it, but it was about whether or not when was the environmental review undertaken?
Yeah, what I was basically asking is, are we dealing with a CEQA document with a 2023 date or a CEQA document with a 2031 date?
The CEQA document was with the 2031 date. The idea, the issue before the board is whether or not, notwithstanding the environmental review that the city did, is whether or not the regional board needs to go through, you know, even though it's not necessarily bound to do so under the law, and do it all over again.
we're not really asking it to be done again. We're just asking that the environment see no significant impacts, which is consistent with a negative declaration.
Yeah, and I think you misunderstand the negative declaration there. I understand this point had to be raised and litigated with the entity that adopted the negative declaration. You'd want to hold the city to task to put the endpoints in and say, look, if you're really going to adopt a negative declaration, what we're going to have to do is make sure that there's no more traffic after 2023. You make that complaint, you got a case against the city.
Well, we made the comments. We commented on the neg deck.
And did you follow up?
Well, that's the problem. That
Yeah, I think that's the problem.
They didn't notify us of what was going on, and by the time we found out about it, it was already it had already been certified. But the issue really, and I guess that's why I labeled this chart environmental justice, because I did read up on CEQA, and really the way it is handled is in the courts. And so when you have communities that are the deplorables, if you want to call them that, people that just go to work every day, they don't have time for this.
Is that you?
That's me. You know, I've lived in the same place for 30 years. And there's someone, the agencies, and I don't know why this, I don't know who's supposed to be doing this environmental justice. That area, the city of Sacramento, is deemed an area for marijuana grows, indoor marijuana grows. They moved that over into that area. And so, you know, we don't have the money to go do legal challenges or anything like that. I'm just bringing this to your attention. This is not the showstopper, because I think the, you know, unclassified landfill, I think, is more of a problem.
So I am concerned. Are you saying that you're a member of a disadvantaged community?
No, I'm just saying that people in general that aren't.
Because I'd be careful using the phrase environmental justice if you've got a CEQA complaint.
Well, I'm not pursuing it any further. I'm bringing it to your attention, and I have no intention to pursue it any further.
I think we should get back on track here a little bit.
That's right.
And our issue is, in terms of the environment, is the groundwater being protected?
Certainly. I think we have a heightened issue. If environmental justice is being cited, I think it's our job to make sure that there's not an environmental justice concern here that's not being met.
Well, I may have used the term improperly then, so I would retract that term, environmental justice, because maybe I don't understand what it really means. So
I think just generally we're talking about, you know, where there are environmental issues due to institutional racism, due to poverty, due to, you know, putting the burden of environmental harm on disadvantaged communities. And so that's why if you raise environmental justice, that really piques my ear. I want to make sure that we're doing everything we can to make sure that there is not that type of institutional racism or institutional overburdening of a disadvantaged community. And so that's why I want to pause and just be absolutely sure about what we're talking about here.
Those are loaded words.
Okay.
I would add that, CEQA or not, our decisions are still bound by the state board's anti-degradation policy.
So I think we understand that.
Can I just make a comment on that? Because when the WDRs were tentatively circulated, the anti-degradation, when the WDRs addressed the anti-degradation policy, it said that since we have containment, the anti-degradation policy does not apply. I would beg to ask you, where is your containment on LF1?
Well, those findings were subsequently revised.
So have you done an anti-degradation analysis? Because you do not have containment to quantify what is being released in the environment and what can be done to address that through treatment and or control. I don't see anything in the WDRs that say that, address that.
I'll defer to technical staff, Brad or Rob, if you wanted to get up and respond to that or address those issues with regard to our compliance. But the anti-degradation, there are anti-degradation findings within it, and those findings, to a certain extent, you know, with any other technical insights that can be provided here, more or less speak for themselves.
Well, all I would say is if you do not have containment, you're discharging to land, and an anti-degradation analysis needs to be conducted.
So just again, I'm trying to make sure what terms you're saying. I think, David, if I'm correct, the initial anti-degradation analysis said no degradation because of containment. Those findings, as David remarked, were revised to essentially say that we acknowledge that there's not a liner. There may be limited degradation, but the fact that we have a functioning landfill that is operating with respect to the applicable laws and regulations, that's a benefit. And the fact that there's only minimal degradation occurring, I think that's really what the findings were revised to say. When I said let's defer to technical staff, I'd like to invite them to comment on whether there are any water quality impacts outside the boundaries of this facility and whether they're impacting drinking water.
Most times I've seen when a neg deck's been done, it's gone through a checklist. It's a pretty thorough checklist addressing all issues, some of them outside of this board's purview, but some of them certainly within the purview of this board. Was that kind of what was the process for doing the anti-deg analysis?
Right. So as I noted in the presentation, that we basically considered the totality of everything the WDRs were going to require and restrict to make the anti-degradation analysis. We have restrictions on types of waste. Types of waste that generally cause groundwater degradation are not allowed. That's, MSW, putrescible materials. And then we're also requiring, it's an interim cover O&M plan. And they're not going to be allowed to discharge waste during the rainy season. And the interim cover O&M plan needs to be submitted. It's a requirement. And it needs to address primarily how infiltration will be, stormwater infiltration will be restricted. And that's right out of Title 27. We can't prescribe that the interim cover must meet some conductivity number. It's just Title 27 talks about minimizing stormwater infiltration. That's what the plan that they need to submit will do. So it's types of waste. It's interim cover O&M plan. It's ongoing landfill gas extraction. A variety of things were considered in totality to measure compliance.
And corrective action.
And corrective action.
So corrective action. So if there is an indicia of a release, corrective action to some extent is required. Right. And and that corrective action is an important part of compliance with anti-degradation policy, because otherwise the anti-degradation policy, if you were to require it as absolute, it's containment it's containment to the extent possible and then corrective action to address those releases. Because otherwise the interpretation would require, anti-degradation policy would require the immediate closure, and not only closure but clean closure of all existing unlined landfills, and that much has never been suggested by the state board or the U.S. EPA.
Can I respond to that? I have an example here that I just want to bring into the picture. So this is a half gallon, and if it had vinyl chloride in it, if I mix this in with 1 billion gallons of water, which is about 1,500 Olympic-sized swimming pools, if I mix that into 1,500 Olympic-sized swimming pools, would you drink that water? Because at that point, it is at the MCL for drinking water. So the whole idea here is containment. So anti-degradation has to do with treatment and or control, not corrective action. Not after the waste has been released and now you're trying to clean up. So if you try to remove this half gallon from 1 billion gallons of water, that takes a lot of effort. So the wisdom of the regulators through Subtitle D and Title 27 is containment. And if you can't contain it, you have to do an anti-degradation analysis.
I'd like to respond to this analogy. This landfill will not be taking a gallon of vinyl chloride. They'll be taking rubble construction debris.
Okay, but let me ask you this. If you had contaminated waste in a landfill and now you put...
They're not allowed to take contaminated waste.
No, if you already have contaminated waste in a landfill.
I would suggest that the discussion has gone a little
Okay,
far.
all
I
right.
want, if we're not answering the board's questions, I'd suggest that we proceed
Right.
through the hearing.
I would like to move on to something else. Do you have evidence that this was constructed in a gravel pit? You made that,
It's in the WDRs. It's in the findings of the WDRs, and it's in his presentation.
Yeah, there's no contention that it was not.
okay. Are there any other questions or comments? Very good. Thank you. I don't have any cards. Are there any interested persons here wishing to comment?
Chair Langley, we had some time left for some rebuttal. We'll make it very short. Thank you, Chair Longley. Tess Denham on behalf of L&D Landfill. I have just a couple of very short comments to make. First, with respect to the negative declaration component, I think for me, the way that I've looked at this is that RACE is trying to improperly use the WDR process to contest a negative declaration that they didn't do during the legal time limit, what they should have. But I want to make sure we understand with respect to the traffic impact. Within the negative declaration response to comments to the same comment that RACE did make to the city, the response was that upon further closure of the landfill, the majority of the vehicles currently accessing the landfill would instead likely travel further east on Jackson Road along the southerly edge of the Rosemont neighborhood on their way to the Kiefer landfill. Therefore, mobile source emissions associated with landfill traffic would likely increase in the vicinity of the Rosemont community, not decrease, as was depicted by Mr. Jane. So I just wanted to make sure that they did address his comment, and that just saying that the closure of that landfill will mean that all the traffic impacts go away, that is not true, because that waste is still going to have to go somewhere. The next closest place is Kiefer, which is right along the same area of Rosemont. So I just wanted to make sure I clarified that quickly. And then just quickly on the anti-degradation analysis, I think it's really important to understand, when we talk about anti-degradation, we talk about, one, does the policy apply within the situation? And then the policy, as we all know, applies where you have a high-quality water, and if the water board is going to allow degradation to that high-quality water. The finding within the tentative order is that no degradation is being allowed via this permit. And so the board staff has done their analysis to make a determination that they aren't allowing degradation. So those BPTC type findings that we typically talk about in conjunction with anti-degradation don't kick in, because the finding in the permit and with the prohibitions and all the corrective actions is that no degradation is being allowed. So I just wanted to make those short clarifications. Thank you.
Thank you very much. We'll now take closing comment by staff.
Yeah, I'll provide a closing statement and
Recommendation.
And a recommendation. Now, I do want to thank the board for engaging in listening to this conversation. I have no doubt that RACE is approaching these issues, as a concerned citizen. And I do sympathize with them. CEQA and the Title 27 regulations are both fairly complex statutes. CEQA, as a statutory scheme, unfortunately sometimes elevates a process over substance. There's very strict timelines that have to be followed, and you get a very good opportunity to challenge actions, provided that you make your challenges within the appropriate timelines. It appears that the RACE wanted to challenge a negative declaration that was adopted by the city and missed the timeline. And they came to this regional board asking for another chance at that. we're entitled to rely upon the city's action and to not duplicate efforts, and I think that's what's in the proposed order. With respect to the technical arguments, I am satisfied with the discussion that our technical staff put together in their response to comments in their presentation today, that the LND landfill expansion is entirely consistent with applicable federal and state laws. I would add that that we've done the appropriate work to ensure that there won't be any water quality impacts by virtue of this expansion. L&D appears to be a good actor, and I understand it's tough to operate new landfill space in the state of California, and country in general, but especially in the state of California. So you look to, rather than lateral expansions, there's a few facilities that have expanded vertically, which tends to be less of an environmental impact than a lateral expansion. So that's the proposal that's on the table. Our technical staff has reviewed it. As mentioned extensively, the city approved a conditional use permit and through the use of a negative declaration. I suggest that the board move forward and adopt the WDRs as proposed.
Any further discussion by board members? Is there a motion?
Motion to approve the WDRs.
There was a change of date proposed. The staff had no objection. It was changing that one date for the
apologies.
model
Yeah,
study
I should have.
with
late revision to 2020, as noted in
the 2020, the end of January 2020, January 31st, 2020.
And all the dates that are dependent on that date.
That right.
So motion with the corrected revision of the date.
Thank you. Do I have a second?
I'll second.
Raji moved. Denise seconded. Call the roll.
Ms. Brower?
Yes.
Ms. Kadara? Yes. Mr. Schneider? Dr. Markham?
No.
Dr. Longley?
Aye.
Motion carries.
Out of curiosity, Dan, what was your rationale for voting no?
Well, I've only been on this board since 16, and I inherit a lot of decisions prior. There's a lot of old land waste facilities in California, and we have to live with that legacy. To me, this is a chance to make a decision on essentially a new landfill, and so that's why I vote no. It's an expansion for me is more like a new one.
So
I think it ought to be closed.
Can you explain why? So you want to close the landfill?
Yes. Yeah, I think I buy into the argument that it's an unlined facility. There's potentially a threat to groundwater. I've seen what kinds of waste come out of construction. I think there's potentially a threat. So I think it's time to say goodbye to that one and move the waste to a facility that's fully lined and up to snuff.
Very good. I think this is the last item on the agenda today. Is that correct? Oh, yes, we have information item. Very good. Yes, we have it. Give it 3 minutes stand-up break. Tell you what, if you just don't mind, if you don't. Board's back in session. Board's on agenda item 10. This time the board will hear a presentation on implementation of whole effluent toxicity, effluent limitations, MPDS permits. This is an information item only and no action will be taken. Although the board may ask questions and provide guidance, direction to staff. After the staff presentation, Central Valley Clean Water Association will provide a 20-minute presentation. Interested persons will then be allowed 3 minutes each to address the board. Tom, are you PPIC today? Something else, okay. We'll now hear the staff presentation.
All right, good afternoon, Chairman Longley, members of the board. My name is Jim Marshall. I'm a supervising engineer in our Sacramento office, and I am the MPDS program manager for the board. I'd also like to introduce Carrie Holmes up here at the staff table. She's a senior engineer in our MPDS permitting section. She's had a lot of experience previously in enforcement of toxicity issues and working with dischargers. So I've had her up here to maybe help me answer some questions. There have been some recent programmatic changes regarding toxicity and MPDS permits that impact many dischargers. So this presentation is intended to provide some background and education on toxicity to help you make decisions on future permitting actions. Before jumping into the toxicity discussion, I want to just provide a quick background on the MPDES program. MPDES stands for National Pollutant Discharge Elimination System. The MPDES program was created in 1972 by the Clean Water Act to address water pollution by regulating point sources that discharge pollutants to waters of the United States, including wastewater and stormwater. Today I will be only talking about regulation of wastewater discharges. So like what discharges from municipal wastewater treatment plants and industrial facilities. US EPA delegated authority to the regional boards to perform permitting and enforcement aspects of the MPDS program, but US EPA retains oversight responsibility.
Hey, Jim.
Yes.
The IT people would like you to speak into the mic a little more because the webcast is too quiet.
Thank you. In this presentation, I will discuss what whole effluent toxicity is, how it's measured, and why it's important. Whole effluent toxicity as a regulatory tool, what are the regulatory decisions that we have to deal with? Current whole effluent toxicity permit requirements and some of the issues that we have, and then talk a little bit about the statewide toxicity provisions that are being in draft right now and some future permitting decisions related to that. So this is a fairly complex subject, and in many cases I will just be only scratching the surface. So please feel free to stop me at any time to ask any questions. And I think in the audience today we have some of the best toxicity experts in the area, so if it gets too detailed, we have a lot of backup, that's for sure. So what is whole effluent toxicity? Whole effluent toxicity, or WET, is the aggregate toxic effect of a sample measured directly by an aquatic toxicity test or bioassay. WET can be acute or chronic toxicity, where acute toxicity is a lethality to organisms, and chronic toxicity is a sublethal effect, such as growth or reproduction. In this presentation, I will be focusing on chronic whole effluent toxicity because it presents the biggest challenges. Acute whole effluent toxicity is important and is regulated in our permits, but is generally not an issue for dischargers today. We're not really seeing any acute toxicity in wastewater effluents. All right, so how is wet measured? Aquatic toxicity tests are controlled laboratory experiments that measure biological effects of a test sample on aquatic organisms. Organisms are exposed to a test sample and a control sample, and the results are compared to determine if the test sample is toxic. US EPA has developed standard test protocols for toxicity testing. For chronic toxicity test, the US EPA method calls for 3 species: a fish, invertebrate, and a plant. This table up here has columns for the species that are used, the test type, the toxicants that are common for that type of species, and the endpoints that are measured for the test. So for the fish, we use the fathead minnow. There's a picture here on the right. It's a 7-day test. And the endpoints that we look at are growth and survival. For the invertebrate, it's the water flea that's used, and it's Ceradaphnia dubia. It's also a 7-day test. And the 2 endpoints that we look at are reproduction and survival. Finally, the plant is green algae. In Selenastrum, it's a 96-hour test, and we look at growth. So for chronic toxicity tests, we probably see we do see the majority of toxicity in the Ceradaphnia dubia reproduction, and for the algae growth. Pretty much like 80 to 90% probably of the toxicity that we see. All right, so in aquatic toxicity tests, organisms of a particular species and age are held in test chambers and exposed to different concentrations of a sample. Observations are then made at predetermined exposure periods. At the end of the test, the responses of the test organisms are used to estimate the effects of the test sample by comparing the control to the sample. So in this picture here on this slide, these are the test containers. If I get the mouse working. So on the far left, this would be like our control sample. And for each of these samples going further, we add higher concentrations of the effluent. So for like in this example, this first one has 6.25% effluent. And then typically on these dilution series, these are called, they double the concentration of the effluent each step up. So it's 6.25, 12.5, 25, 50, and 100% effluent on the far right. In this case, they have replicates also. The more replicates you have, the more statistical power you'll have. So that's why they have the replicates. And over here on the right is a lab technician working on a test. This figure down below with the graph is called a dose response curve. And so on the far left is the control, and it's the percent survival and the concentration of the effluent down here. So at 0% effluent, that's the control. And then as you go to the right, you add, this is a 6.25 and the 12.5, and you go down, you see that all of a sudden it drops down and survival drops down. And what you're trying to see is if there's a significant effect between these results and the control. So it looks like on here, if you're to look at this, this one is the first one. It looks like probably has a significant effect between the control. Let's see, I think that's about it. So here's a figure, just kind of gives some average cost for laboratory costs. This comes from the economic considerations document that State Water Board has put together for their new toxicity policy. If you have the multiple concentration test, which I just showed you, has the dilution series, this is the cost over here on the far right. If you're just going to do single concentration test, I'll kind of talk about that later, where maybe you don't need to do a dilution series, you can just do single concentration. This is the cost. So just kind of give you an idea of the scale of the cost for conducting these tests. All right, so why is wet important? Whole effluent toxicity testing is an important tool for water quality-based toxics control. For the protection of aquatic life, US EPA recommends an integrated strategy with 3 control approaches: the chemical-specific approach, the wet approach, and the biological criteria bioassessment approach. The chemical-specific approach is the predominant approach for NPDES permitting. This includes monitoring the effluent and the received water for specific compounds and limiting the discharge to ensure that water quality criteria are not exceeded in the receiving water. So this is an example where you'll have maybe criteria, water quality criteria for copper, and you'll set limits based on the criteria, like in a maximum daily, average monthly limit in a permit. The biological assessment or bioassessment approach is the least common approach used in NPDES permitting. This involves surveying the types and numbers of organisms present in the water and comparing the results to establish benchmarks of biological health. Bioassessments directly measure the ecological health of a water body to monitor the cumulative impacts of environmental stressors. In my experience, the most common use of bioassessments is when somebody wants to use a mixing zone, and they'll use this to demonstrate that the mixing zone is appropriate. So for the wet approach uses wet testing to directly measure toxic effects to organisms. It provides an overall check of the toxicity of a discharge. Some of the advantage of using wet controls are that wet tests evaluate integrated effects of all chemicals in a discharge, which allows the ability to identify synergistic or additive effects of multiple toxicants. So example of this is, metals and pesticides have additive effects. So the toxicity of metals and pesticides can be additive, and whereas maybe the individual metals maybe don't exceed the criteria, but the combination of two may, and you can catch that in a wet test. Also, wet testing can measure toxicity caused by compounds for which there are no chemical-specific numeric criteria for protection of aquatic life. I see this as another example of where, there's sometimes you'll find that maybe polymers or other chemicals that are being used in a wastewater treatment facility are causing a toxicity, but you probably wouldn't be able to catch it through chemical-specific monitoring. Finally, although bioassessments are also directly measure biological effects, the wet approach has an advantage because bioassessment studies are more difficult to conduct and are not easily implemented in permits as permit discharge requirements. All right, so now I'll discuss how full effluent toxicity testing can be used as a regulatory tool in NPDES permitting. Wet testing is an important regulatory tool because it provides a direct screening to warn when an effluent may be toxic. The typical wet permitting approach includes wet testing and triggers or limits that set toxicity thresholds that, if exceeded, require follow-up. This follow-up to address toxicity is called a toxicity reduction evaluation, or a TRE. So this is our wet permitting approach flow diagram. Kind of give you an idea how we go through this. So we start with routine toxicity testing. We take the results from the tests. We check it against some threshold that we've used to determine whether the sample is toxic. If it's not toxic, we're just going to go right back to routine monitoring. If it is, we need to check it a little further and do additional monitoring. It's called accelerated monitoring to see if there's a pattern of toxicity. If there is, we check the trigger again. If we have hits again, then we're going to drop down and initiate a toxicity reduction evaluation to identify, what's causing the toxicity and control the toxicity. All right, so wet testing provides important information, but there are several challenges when using it as a regulatory tool. One challenge is the interpretation of the data. With any data, the first thing you want to do is check the quality assurance, quality control, and make sure it's valid data. The toxicity tests are very complicated, and in many tests, and with just many test criteria. So for dischargers and regulators that are not toxicity experts, the lab sheets are very daunting, and it's difficult to identify QA/QC issues. It's not uncommon that we get results that are reported as valid results, but as you start to dig into it, you find somewhere along the test that something doesn't look right, wasn't meeting certain test criteria, and so it makes the results questionable. Another issue is there are many testing criteria that must be followed, but the labs are allowed several options within the EPA method. It almost seems like you're not comparing a consistent standard. So for chemical constituents, regardless of which lab you go to, the samples are compared to the same standards, the water quality criteria. For toxicity testing, samples are compared to a control, which can be different for different labs. In the next couple slides, I will provide an example of a situation that we encountered. If I can get my thing to work. So this is an example of a groundwater cleanup site that is removing volatile organic compounds using granulated activated carbon. The facility did not have a history of toxicity, but decided to change toxicity labs to save shipping costs, and all of a sudden the effluent began demonstrating toxicity to algae, where the test endpoint is growth. As part of the toxicity evaluation, the discharger split a sample and sent samples to the new lab and the old lab. The new lab estimated toxicity and the old lab was not toxic. So this prompted a detailed discussion between the labs regarding their test protocols. They identified a few differences that may have been impacting the results. So the EPA method allows some variability in lab control water, which may have been a factor in the toxicity results. The lab controls for the new lab demonstrated greater growth than the lab controls for the old lab. So this means that the new lab, the effluent needed to meet a higher standard for growth than the old lab. So you're comparing to this effluent to this control. In one lab, you only have to grow this much and not be toxic. In the other one, you have to grow this much to show you're not toxic. Also, there's different test protocols that are being used, such as glass containers versus plastic, continuous shaking versus hand shaking, and the differences in the sources of the species, the lab cultured versus outside supplier for their algae. So for the algae test, there can be issues with the algae sticking to the sides of the containers, and so that when you go to count the number of cell growth, you don't count everything that's there. And also maybe they don't receive all the nutrients that are in the water. So if you use a glass container versus a plastic, it can affect how much attaches to the sides. Also, however, you usually try to avoid this sides getting stuck on the sides as they shake it. And sometimes they have, things you can put them on. They always are shaking to kind of keep it off. Otherwise, they can do it by hand. So that could have impacts. But all these are allowed by the test method. So in both cases, there's valid data, but you have two results, one toxic and one not. And I'm not really bringing this up to say that the toxicity test shouldn't be used or it's not a good tool. It is an excellent tool. Just kind of point out the challenges to try to use it in a permit as a regulatory tool to make regulatory decisions. All right, so another challenge is assigning environmental significance to the wet data. So how do we use the information from the laboratory test to evaluate environmental impacts? We do this by establishing the toxicity trigger or limit, which interprets the data to mean the effluent could be causing toxicity in the receiving water. We need to develop toxicity triggers or limits that provide reasonable protection of beneficial uses. Two considerations when developing the trigger is whether a mixing zone can be allowed and the statistical approach to be used to evaluate the toxicity data. So mixing zones can be considered when dilution is available. A mixing zone is a small area in the receiving water near the discharge point where the effluent discharge is allowed to mix with the receiving water before checking with compliance with the water quality objectives. So a mixing zone would allow a higher trigger. On the slide here, there's kind of a depiction of what a mixing zone looks like. You have your discharge coming in. If there's no mixing zone, you'd have to meet all requirements at the end of pipe, it's called, at the end of the discharge pipe. If there is enough dilution or diluting flow in the receiving water, you may be able to mix with the receiving water and get some kind of dilution and not have to meet the criteria in here about the end of the red mixing zone. That'd be the chronic criteria.
And you're showing different mixing zones for the acute and chronic.
Yeah, so this is something out of like NPDES Permit Writer's Handbook where it shows an acute and a chronic mixing zone. I'm referring to the chronic. We don't often allow acute mixing zones, but in this case, there are different mixing zones for acute, chronic, and human health. But in this particular case, I want to point out the chronic. And in the next slide, I will kind of show you how a mixing zone affects how we evaluate compliance with the toxicity test, how it relates. But first, I'm going to talk about the different statistical approaches to kind of another decision you have to make when you're coming up with what trigger to use. So the EPA method does allow several statistical approaches to evaluate the toxicity data. The three primary approaches are hypothesis testing, the point estimate, and test of significant toxicity, or TST. So in this figure, this is that same figure I showed you before with the dose response curve. And so you have survival on the left, the concentration on the right. This first diamond is the control. And in this, I'm assuming that this first concentration, this is the 6.25% effluent, it's not significantly different from this control. And also the 12.5% is not significant from the control. So there's no toxicity, not showing any toxicity. But the rest of the concentrations are at 25%. We're saying that's going to be significantly different from this control, and so on. So for hypothesis testing, it's the no observed effect concentration is the approach that we typically use here at the board. And this is the highest concentration with no significant effect from the control. I think the main reason we use this at the board is we implement our narrative toxicity objective, which is no toxic and toxic amounts, and the NOAC is the concentration where no toxicity is being seen, so that's often used in our permits. The other, another statistical approach is called the point estimate. The inhibition concentration is one of these, and we often use what's called an IC25, which is an estimate of a 25% reduction. And so this is just going to use all these data points to come up with some kind of estimate of where you get about a 25% effect. Oftentimes the IC25 and the NOAC are similar, but the NOAC is really dependent on what dilutions you actually select. Like in this case, if we had selected a dilution that was in this area where the IC25 is, it's likely that it would also have not a significant effect, and the NOAC would be here, but you're really confined by the dilution series that you use. And finally, there's a relatively new approach that US EPA prefers, and that's the TST approach. And this approach doesn't use a dilution series. Instead, the effluent concentration that is environmentally significant is tested against the control. So for example, if we were to say there's no dilution, this is where I was going to kind of bring in the mixing zone discussion and kind of compare how you use it in toxicity. So if you were to say that there's no dilution, then we would be checking the 100% control, the 100% sample against the control. So in this case, it looks like it's likely that there's toxicity in this 100% control. However, if there was actually dilution allowed, say there's a 7-to-1 dilution, that represents this area right here, you would be only checking this concentration versus the control when you're evaluating your trigger. So if the environmentally significant dilution is here, but you're using this to make your determinations, you may be a little overprotective. All right, so the challenges of interpreting data and implementing permit controls are not solely a wet issue. There are similar challenges for a chemical-specific approach, and regulators need to be diligent when establishing appropriate permit controls. For the wet permitting approach, however, the regulatory decisions can have significant impacts on dischargers with sometimes little environmental improvement. So here's the flow chart again of the wet permitting approach. And I showed early. And the final step on here is the toxicity reduction evaluation. These first steps are, all requirements in the permit. You have monitoring requirements in the permit. You have a trigger that's in the permit. You have accelerated monitoring that's in the permit. And there is requirements to conduct toxicity reduction evaluations in the permit. But once you get into a TRE, it's very site specific. And it's, we say it's more like kind of out of the permit, and it's really, they can be done so differently for different discharges depending on what the situation is. So now I'm going to talk about, the toxicity reduction evaluation process and how it can be challenging and can be costly for dischargers. All right, so US EPA TRE guidelines include the following phases. I think that's wrong. I'm sorry. Back up. I'm sorry. TRE is a process to reduce or eliminate toxicity. US EPA has developed guidelines that provides a framework for conducting the TREs. But they're, like I said, they're very site-specific. They can be very complex, and sometimes they could be simple. It's a large range in cost as well. The Central Valley Clean Water Association, or CEVICWA, has conducted a toxicity special project, and part of this was to come up with streamlined processes for conducting TREs and try to make them as, economical as possible. This is a very good study. They worked with board staff in a collaborative way, and they have come up with these tools that we use in our office, and they'd come up with some quality assurance checklists that we actually, I could have mentioned that back when we talked about the QA stuff, that we have started to use also. That's helped us in reviewing the data that's come in. So these are the stages of the TRE. It starts out with just an information and data acquisition and facility performance review. This is where you're going to look at any data and make sure it doesn't look unusual from your effluent, make sure your facility was operating properly. And then there's the toxicity source evaluation. This is where you look up into your collection system and try to address toxicity at the source, maybe through your pretreatment program. A toxicity identification evaluation. This is where you're going to try to identify a toxicant through toxicity testing. And you do this by doing different type of treatments on the test to, maybe you would filter for metals and then retest and see if the toxicity goes away to identify the type of toxicant. And then you finish with the toxicity control evaluation and implementation. So once you have identified what the problem is, you can go right to make sure you've controlled it and you've implemented it. And you don't have to go through all these steps from the beginning to end. I mean, you can start at the first step and realize that, hey, it looks like our biological system wasn't working properly. And so they correct the problem and retest, and they don't show any toxicity, and so you can get out of the TRE really quickly. Other times, you spin and spin, and you can't figure out what's going on. So as mentioned, TREs can be challenging, especially when the toxicity is a low level and intermittent. And that's kind of a lot of the toxicity that we're seeing today. A lot of our municipal wastewaters are tertiary treated wastewater. It's high quality discharges, and so the toxicity we're seeing is very low level. And it's not uncommon to get inconclusive findings in the TRE. And sometimes the toxicity will just go away, and you don't know why. And then other times, once you get into a TRE, you can kind of get in this loop of endless testing, and there's not really an off-ramp to get out. And this is where, like I mentioned, where carried work, you can work with discharges and kind of work through that and see if there's the appropriate way to go on these TREs. So this figure here came from CEVICWA's.
I'd just like to ask a question on that.
Okay, sure.
If you could go back one slide on, since we're talking, well, here's TREs, also the one that came up. Problem I've seen with TREs oftentimes, and tell me if I'm wrong, particularly when we're looking in a stream and there's been a spill, by the time you get people out there so they can take samples for TRE, the spill is dissipated. The concentrations have dissipated, so you really don't have you may see fish kills and things of that sort, but it's pretty hard to do a valid toxicity assessment other than maybe identifying the constituent. Is that valid or?
Well, I think when you're talking about effluent, we're usually talking about lower levels of toxicity, especially with the chronic toxicity test. You're looking at sublethal effects.
So, yeah,
But-
you're doing
but
a
do we-
continuous flow off a system that there's some stability that might be different.
Yeah, well, so like the issues that we see in TREs is that you'll get some toxicity, but it's not persistent, and it's, so that you'll check it once, and then you go back to try to see if it's there again, and it's gone. So it's hard to do follow-up to really get and identify it. And so that's one of the issues with sometimes in these TREs. You get in there, you might get a toxicity, but by the time you turn around and try to address it, it's gone. And then maybe it comes back again a few months later, then you're back into this accelerated monitoring. So you're doing a lot of extra toxicity testing, kind of chasing your tail a little bit, and you may not be able to find it. But that's one of the things that Civico has done, I think, with their toxicity specials project, is kind of come up with ways to do things differently, not always just try to identify a toxicant. If you can just try to find the cause of it, like maybe the amount of polymer they're using in their tertiary filtration system or something like that. Change things like that, and you might be able to catch things. So, so to kind of go to that point, this is one of the figures where Civico looked at 35 different wastewater treatment plant TREs that were done, and this shows the percentage of these different types of results when they came out that kind of demonstrate how they got out of the TRE, what they found from the TRE. So this blue here, so 26% of the TREs that were conducted, there was like an unknown cause. So they had TRE, they had toxicity, they went into accelerated monitoring, they had some more toxicities. Now they're in a TRE trying to figure out, but all of a sudden the toxicity just goes away. They never really figure it out. Another part is this facility maintenance or the collection system maintenance. So nearly like 50% of it is maybe they were conducting maintenance at the facility, or they were doing some kind of upgrades at the facility at the time they took the sample, and they determined that, hey, it looks like it was not really represented effluent because they were doing these other things that were going on. So in this case, we're looking at about 75% of the time you may have gone into a TRE, but there wasn't really any change to the facility, most likely as a result of it. But it's not to say that it's not worth going in and checking. If you start to see toxicity, you still need to check it out. But I'm just making the point that sometimes you get a hit, but it doesn't result in any change of how you operate necessarily. So about 11% of the time, they actually identify a toxicant. And then the 6% is the chemical usage. That's what I was kind of talking about. Maybe you change chemicals, all of a sudden you start getting toxicity, and so you realize that. And then the other 9%, that's that source control part of it, where they look up and there's maybe a significant industrial user or something like that that may have dumped something or not meeting their pretreatment requirements. So these are some costs for toxicity reduction evaluations and toxicity identification evaluations. And I want to say this is just a ballpark figure, and it's not a large data set. But again, it's just to kind of give you an idea. I mean, we've seen toxicity reduction evaluation a lot more than this, and it's possible maybe you could have some lower than this potentially. But I just kind of want to give you a ballpark. Once you go into our TRE, it's kind of like this minimum cost of maybe $20,000, $30,000 that you're kind of in this. And I mean, just trying to make the point that the trigger that we use to trigger into these, we need to be diligent and make sure that there is an environmental impact that could be occurring. Toxicity tests are a tool to kind of identify toxicity before it becomes a problem, but it's just, like I said, it's just an issue with trying to use it in a permit, especially when I talk about later about using it as a numeric effluent limit. There's just some issues with using toxicity data.
Who's calling the shots on the sampling and when this happens?
Who's calling the shots?
The plant operator or us?
Okay, so the permit requires routine monitoring and the accelerated monitoring. Once you get into a TRE, what we ask them to do is they give us an action plan to how they're going to conduct the TRE. And within that, they kind of tell us this is the monitoring frequency that we're going to use. And, when toxicities occur, these are the things that we're going to be checking. It kind of gives them a plan of action depending on that site-specific situation that happens at that time.
So based on your experience, you probably have a good opinion of what's appropriate for a sampling protocol.
Right. And typically what I've seen, it's usually like they start to go like on a monthly basis, depending on if they're getting toxicity. One way you get out of a TRE, and that's where the unknown come up, is if you say you take sample it once a month and you get no toxicity for 4 or 6 months, then maybe we're done, because you can get some slugs that come through a treatment plant potentially, I guess, that maybe one hit, but then you won't be able to find it later. So, but like I said, I think that also that tool that Civico had developed, it kind of gives some guidance on what's the best approach to take. And we have some really good toxicity labs that do a lot of good work on TREs that, like I said, do a really good job and know what they're doing. All right, so that's it for TREs. So I want to talk now a little bit on, what are the wet permit requirements? And so the regulations do allow a wide variation of permit requirements, such as the monitoring frequency, the statistical approach that we use, or whether we use triggers or limits. And there really isn't much consistency throughout the state. And there is a long history of disagreement between US EPA and the regional boards, especially on the topic of whether numeric toxicity limits are required for chronic toxicity. And so here's some history. It goes back a long time. Back in 2002, Region 4 issued a couple permits with numeric chronic toxicity limits, and the permits were petitioned to the State Water Board. The State Water Board issued a water quality order in 2003, and they agreed that there needed to be some statewide consistency, and so they committed to updating the SIP is the state implementation policy, has toxicity provisions that we follow, and they committed to updating them within 1 year. And so that was 2003, and they are now, moving forward now, looking like it's getting more imminent, but we're talking 16 years ago. And so US EPA this whole time has really thought numeric chronic toxicity limits were needed if there was a toxicity issue. And so after a while, they started to get concerned about it's taking too long, and they started mandating regional boards to start implementing numeric chronic toxicity limits. Regions 4 and 9 now include numeric limits for chronic toxicity, but the other boards haven't taken it up yet. And the state board's toxicity provisions, they look like they're scheduled for October of 2019, but we'll see how that goes. So the Central Valley Water Board preferred approach, since I've been here in the 2001, has been, if there is a reasonable potential for chronic toxicity, we include a narrative limit that says the discharge shall not cause chronic toxicity in the receiving water. And they're in compliance with this limit as long as they're implementing the wet provisions. And the wet provisions is kind of what I've already talked about. It's a numeric trigger, accelerated monitoring, and the TRE provisions. But as mentioned, US EPA has been pushing for numeric chronic toxicity limits for many years, and in August 2016, they issued an initial objection letter to the board regarding our draft municipal general order. This is the general order for publicly owned treatment works that can meet effluent limits with no dilution. These are primarily tertiary facilities. So the board did adopt the municipal general order in December 2017 with the option to include numeric chronic toxicity limits if there was reasonable potential for chronic toxicity. And since that time, we have essentially been complying with the US EPA mandate, but that's in the sense that we were not bringing permits forward that did have reasonable potential for chronic toxicity. So this was resulting in some permit delays. This is a controversial issue for the POTWs. That's the publicly owned treatment works. Staff's not necessarily in agreement with this approach because it doesn't change the toxicity control procedures in any way. It seems to put dischargers in possible legal jeopardy for really no added environmental protection.
So how do you come up with numeric limits when basically, and probably my misunderstanding of toxicity, but it may be due to a number of factors or synergistic effects and things of that nature. So these toxicity units, how are they actually derived?
A lot of statistics.
Yeah, the statistics are very complicated. I mean, so it's not infeasible to calculate a numeric limit. I mean, so one of the reasons regulations say, you know, you don't need to have numeric limits to say it's not infeasible. I mean, you could probably calculate it, and the EPA has guidelines for doing it. But it's not, you know, in our opinion, it's also okay to do what we're doing. The regulations allow for an approach that has equivalent level of protection. In this case, you know, toxicity testing, as I mentioned before about all the different issues with trying to implement it as a regulatory tool, it's a great tool for identifying toxicity and catching things early, but to implement it in the same way you would implement a limit for copper, it just doesn't work because, as you mentioned, you get toxicity. Now, what is it? With copper, you go, okay, I have a copper problem. You get toxicity. I don't know what the problem is, and so you need to investigate. So it's more of an investigated type approach, and that's the way our approach is, more of a best management practice type approach, where you identify the toxicity, and then you go take a look at it, and you try to figure out what's causing it. So I guess, you know, why are we, you know, so some recent permits that we've kind of come up have numeric limits to comply with US EPA's mandate. So why are we doing this? So we have recently reached a point where delaying permit renewals is no longer a feasible option because these permits need to be updated. You know, either the discharger has some changes they need made in them based on upgrades, or we need to just update them based on the most recent regulations. And also, I mean, the state board is moving forward with numeric limits in their proposed toxicity provisions, so it really looks like the writing's on the wall anyway. So what we've done in our permits that have been coming up is to address these concerns by dischargers, we understand the concerns, is that we've included compliance schedules in the permit which delay the implementation of the numeric limits. So essentially in the interim, they continue to have a similar approach that we've always used with triggers, accelerated monitoring, and TREs. And this should, in our opinion, take us up until where the new toxicity provisions that State Board adopt come into effect. And so it's kind of like the best of both worlds, I guess, that we are complying with US EPA because we need to put numeric limits, but we've kind of delayed the impacts of it, and so there shouldn't be any immediate impacts to dischargers. I know there's like the principle of it, probably from like Civiqua's standpoint of we don't want numeric limits. But from a practical standpoint, I'd say it's essentially the same regulation that we're doing right now with also complying with what US EPA wants us to do. So a little bit on the state, just really quickly on the statewide toxicity provisions that are proposed currently. So this will establish statewide consistency. It applies to inland wastewater discharges, which is our whole region. It will supersede any basin plan toxicity requirements and establishes new numeric objectives for toxicity, both acute and chronic. Some of the main provisions that are in there, that all facilities will essentially have reasonable potential, which means all facilities will have numeric chronic toxicity effluent limits. It will also prescribe the statistical approach that must be used, so all regions will use the same approach. It's the TST approach is what they're proposing. It also prescribes the minimum monitoring requirements, the test species and methods, and also establishes when a TRE is triggered. It doesn't change the TRE provisions at all, so it just changes a little bit how one is triggered, but it's not that much different than what we currently do.
And this is mandatory, or going to be mandatory?
It would be mandatory, yes.
Yeah, and it appears there's still a lot of discussion about really the validity of this approach, given, as I understand, considerable, the water quality of factors themselves can influence the variability considerably, the variance, if you will.
Yeah.
and that these kind of problems haven't been resolved.
Right, and that's one of the, I guess, the issues that Civico has and other dischargers, and even here at the regional board, is that, as I showed before, you take, one lab gets one result, another lab gets another result. How do you reconcile that? I mean, I would say one good thing about the TSD over the NOAC, or the other approach that we've been using, is it puts the onus really on a discharger to use a really good lab, because the better lab you have, better chance you need to prove that you don't have toxicity, because it uses a different null hypothesis. It assumes that the discharge or the effluent is toxic, and then you need to prove that it's not. In the other standard approach, the NOAC, you assume that it's not toxic, and then you need to see if there's a significant effect to show that it is toxic. So that's where you can have different labs that have different quality controls, and a really good lab will show just a very small change and show toxicity, whereas a lab that has really wide varying data will say, oh, there's no toxicity here, but there's a pretty big change in the results.
And I will say the state board's working very hard to try and rectify those situations, working with the TLAB program to try and rectify those situations. I think, as Jim daylighted, the issue, I mean, if you look at this, it saves a lot of work for our staff. It's really at what cost? I mean, not doing Jim's folks, Carrie's folks spend a lot of time working with small dischargers to figure out whether their discharge exhibits reasonable potential for toxicity. It is a very, very intensive process. And the reason that they invest so much time and energy into figuring that out with dischargers is because they really only want to apply those numeric limits where absolutely appropriate. It is a lot easier from our staff's perspective to just apply the limits to everybody. But what we're kind of presenting to you today here is that has some significant consequences. If you do the toxicity and apply that numeric limit, you very easily can be in a situation where a small community can be forced to not only do the fairly expensive test, again, that's neither here nor there, maybe that's just something that they have to do, but then to spend another $40,000, $50,000, $60,000 in a toxicity study loop, never finding any actual toxicity because the event has passed and the lab results are inconclusive. That's really where we have a problem, where the discussions are ongoing.
We've talked a lot about science today, good science, and this seems to me that in that case, that $40,000, $50,000, $60,000 could be better used in that small community.
And I will say, every once in a while it does catch something. Every once in a while you get a toxic hit, you do the follow-up, and it catches something big, and you stomp out a very significant water quality problem.
You spend a lot of money, come up with a risk, address an issue that should be identified, but if you spent that money other ways, particularly with small communities, you might reduce a hell of a lot more risk.
That's a policy decision that the state board is weighing right now.
When the state board makes these overarching decisions that affect all the regional boards, before they make their decision in October, does this board have the opportunity in our August meeting to perhaps put an opinion in to state board?
I think we submit a letter to the state board. I think that we talk to me about it, and we'll figure out what our comment is going to be. I think that this is an issue that is being looked at throughout all levels of the administration. I know that the state board is engaging with Cal EPA, the Governor's Office, and US EPA on this. So, the way we phrase our particular response to this is to raise the questions, but there are certain ways in which we do work within the administration guidelines to make sure we make our point known and then let them make the decision on that.
Is it appropriate for this board to have a little subcommittee meet with you and come up with something that might be a resolution by our full board?
I would hesitate to say a resolution would be a very good idea, but we could certainly have a subcommittee that would meet on and talk about this issue.
Well, yeah, and another approach might be if we could get this on the agenda as a topic at WQCC.
I think that would be entirely appropriate.
You know, I'm not sure where US EPA comes in. I mean, it's their mandate, even for state board, to put numeric limits in too.
Yeah.
That's another factor.
It's
But that's the problem. It's, oh, God.
So I'm just going to skip, and because of
there's
time.
more than a few third rails out there.
Yeah, you know, the EPA is pulling back on some issues, and it seems like sometimes they don't pull back on the right issues. This is something I'd like to see a lot more certainty to it insofar as its value in reducing risk.
Yeah, and I think, you know, to respond to Dan's comment, I think that there are certain individuals that are very certain as to what the value is. I think we tend to see it a little differently, and so I think the challenge is to make sure that all viewpoints are heard when the policy decision is made.
And impact on small communities has to be one of the considerations.
Well, I know for a fact that Debbie and others in her shoes are absolutely making their point. We'll see if it falls on deaf ears or not.
In fact, establishment, if we're going to go this way, then there needs to be an establishment of a fund for them to pull on.
I wouldn't disagree with you.
All right, I think I'll turn my time over to Debbie then.
It's funny, this is all for NPDES work, and I keep thinking, oh, this is best for things like ag runoff programs, or, you know, what's going on in the Delta, or where you have these synergist effects between a number of toxics.
I'll let Adam tell you that's exactly, you know, that's exactly the framework that we tend to talk.
And this
I'll let Adam weigh in.
You mentioned that, and it actually was ag runoff is the only place I've really seen much on TRE.
I got one more quick question.
Okay.
About taking the samples. Do the labs take most of the samples in this day and age, or do the NPDES permittees take the samples and take them to the lab? I'm concerned about chain of custody for quality of the work. How does it work in this day and age?
That's a good question. I don't know if it's most or how many. I would say discharge. Maybe even labs might be able to answer that, or even Debbie might. But
Debbie can answer that. She knows everything.
I don't want to draw Josie up
because I know some labs take samples, and some probably most dischargers I would think, but I'm not 100% sure.
So I did want to respond to Board Member Schneider's question about toxicity testing and the ag program. It is a useful tool in our ambient water sampling and our swamp program, where we've identified ambient issues. We also do quite a bit of toxicity monitoring in the Delta for the Delta Regional Monitoring Program. And I want to say we've been doing chronic toxicity testing for a long time in our NPDES permits with a trigger. And it has been used and it has identified issues. The issues it's identified in some cases have been problems, and they've been solved. But now I think what we're really wrestling with this toxicity monitoring is I'm making a chart in my mind here, but the toxicity problems that we found have become less and less pronounced, and the signal we're getting from the environment and from the sampling is very low level toxicity. And when we get to low level toxicity, the outcomes of the TREs of trying to identify the problem becomes it's just like trying to, if you're trying to identify a problem with your car, but it only happens once every 6 months when you turn the blinker on or something. It's the same issue. It's very difficult with low level toxicity.
You got that problem too?
Yeah, I finally figured it out. It's every time I turn the blinker on the left hand side. But anyways, it took me a long time. But that is.
And all of a sudden the mailbox goes missing.
And I think that's the problem that we're running into.
Well, my read on this is because of the cost associated with the sampling, there's a big incentive for them to do a very good job.
And that's, I think, some of the argument that we've heard I don't think, we're not saying these aren't good sampling things. These are good things to do. The issue, though, is that, with the sampling and trying to get good quality information, the lab methods for these toxicity tests, they're not, they don't set Jim brought up kind of how often you stir the jar. Well, when the algae adheses to the outside of the jar. If you don't stir it correctly or at a consistent manner, you can actually get a toxicity signal that may or may not actually be real. So again, with these low-level toxicities, this just becomes a very, very difficult thing to chase down.
But the other issue I understand is just the matrix water from one place to another can give you inconsistent results.
What do? Do you just keep testing till you get a toxic hit, or do you get toxic hits and just keep testing till you're clear?
That actually is an exceptionally valid question. I mean, part of the and it might be, I think Jim raised it and Debbie will probably raise it again. Is these things take a long while to exercise. It's not like you just do it in span of 5, shake up the vial and you get it or not. These are living organisms that you're dealing with, and a long test being conducted over a long period of time with lots of variability. It's cool science, but when it has tremendously expensive ramifications for small communities, I think that's where we start raising concerns.
This actually, to me too, as I think about this, is actually much more applicable to being a research tool.
Yeah.
I mean, if we're gonna have a testing tool for these situations, you got to be coming out with the same results, subject to some variability, of course, because it's the biological world.
Let's move on. It's getting late, very late in the day.
Statistics at 5:30 on a Thursday.
Yeah.
This is happy hour stuff, folks.
Yeah, but I have to tell you, I appreciate the discussion because it's a lot. It's right up what we're talking about. So, again, my name is Debbie Webster. I'm the executive officer of the Central Valley Clean Water Association, and we represent a lot of the POTWs, or wastewater treatment plants, in the Central Valley. And we come before you all the time in a matter of that we are very committed to environmental protection. That is what our treatment plants do. They take people's waste and they put it back into the environment and use it again in a safe way. And that's what their job.
Debbie, what's the total length of Civiqua's presentation?
20 minutes or less. I'm going to go fast.
I like the or less. Go
I'm
ahead.
going to try to go fast and skip different
I
things.
won't stop you. Go.
Okay, here we go. I want to just off the top say we don't want to see our effluent causing problems in the receiving water. We don't want to see that. That's something that we are very much committed to. I do want to say I really appreciate Jim's presentation. There was spot on just going over what some of the issues were, teeing up some of what our concerns are and how we got here. I'm going to briefly go over something, but also really kind of try to focus on our test. So basically, I'm going to talk a little bit where we've been, where we're now, and what we know, and where we're going is kind of where I'm looking at doing this. So Jim talked a little bit about the history of this. We've been doing acute testing in our permits for decades. So we've done that. There used to be problems with acute testing. A lot of those were caused by chlorine, because chlorine kills fish. That's why you put dechlorination in your fishbowl. Chlorine, ammonia, a lot of those things, really strong ammonia, those things have been taken care of. We're not talking about those. We're not seeing those problems anymore. But in the mid-1990s, US EPA developed and promulgated methods for chronic toxicity. So are we seeing when we call it sublethal effects, they're typically not dying, it's growth, reproduction, those kind of issues. When they did that, there was a lot of problems, or a lot of concern in the whole community about some of the validity and variability of the tests, and that comes into play. And we'll talk about that in a little bit. In 2000, the State Water Board adopted the state implementation policy, and that mandated that we do chronic toxicity testing in our, or have provisions in our permit as receiving water limits. And so if you would have to be testing for that. The protocol was, if you were testing for that, you had reasonable potential, you would get a narrative effluent limit, you'd have a narrative receiving water limit with a trigger. That was the way things were set up from the very beginning. In 2002, as Jim mentioned, that was the LA region decided to put a narrative in the permit. That permit was appealed. The state board in 2002, again and twice before 2006, said, you know what, there's still too much variability. That's why we chose not to go through numeric limits. There's still too much variability. We're going to redo this policy. We're going to look at these, whether or not it's appropriate or not, and we're going to make a decision then. But until then, it's going to be a narrative. Now, I do want to let you know, for the State Water Board to approve the policy, they have to go through EPA, and the EPA has to approve this too. So EPA has approved the path through the SIP. Let me just make sure I didn't forget. Okay. Do that. Oh, no, I'm not doing this right. Hold on. Let's do that. There we go. So we've been doing this for a while. We've recognized a couple concerns, or I shouldn't say a couple, but concerns. Some of those have been brought up about whether or not we really have effects in the environment and the cost. And I want to just show you, go a little bit more of what Jim was talking about before. So we've got our wastewater treatment plant here. Here's clarifiers, and we have a discharge point. Actually, I think there it is. We will be taking our sample sometime after treatment, but before it's discharged. The wet test stands for whole effluent toxicity, so we're looking at whole effluent. We're not looking at receiving water, and I think you guys mentioned something about toxicity testing. Some programs only do receiving, they're in the receiving water body. They're not doing like a pipe end to treatment type of test. The idea with wet tests is that you want to see whether or not there's downstream effects. And if you look at EPA regulation, EPA documents, they will tell you really what we want to see is what's downstream. And so we want to have an environmentally relevant concentration. And that gets translated again back into something we called in-stream waste concentration or as Jim was showing you that the curve, you would pick a number that says, hey, you know what, you probably have some dilution here. This is what it's going to look like in stream. And this policy is most effective when we use the in-stream waste concentration, or at least this tool. When we started doing this and over a history of finding some low-level effects and not having really a lot of success in identifying them and spending a lot of money, and as we put going through the endless do loop, we started working together and talking with staff. We've had joint workshops with them and with our members. I know the regional boards and certainly some of our members have gone out to the toxicity facilities. And so I would say for you too, if you would like to go and see what a toxicity lab looks like, we welcome you to go to that. Toxicity testing is not the same as chemical testing. When ELAP certifies a chemical, for a chemical, they'll give you a blank. They'll know how much chemical they put into that blank. You could test it. If you're able to get the right answer, you're good to go, or within a certain tolerance. Toxicity testing, which is more about sample population, so they go and they take it. All the labs do it at the same time, and if you're getting in the same range as most of the other labs, that's how you test it. But it's not oh yeah, you got it right or you got it wrong kind of question. And I'm like kind of going, Stephen Clark, you moved up, thank you. He can tell you a little bit more about that if you have questions. So, I'm sorry, I should have gone backwards for a second, just a second. So, from that, we've been working with the regional board about more effective permitting approaches and have really appreciated the work that they've done with us in order to address those permitting approaches. And one of them has been working through in a collaborative study with our members. And I want to talk a little bit with you about that. So our study, we looked at the NPDES. There are 77 POTWs in the Central Valley discharging to surface water. We looked at almost all of them. We didn't have the data for all of them. We looked at almost all of them. There was over 1,000 toxicity tests that we looked at that were just our normal tests. These are, as you can see, these are mostly high-level treatment plants. This is shown in the green. We have a few that have advanced secondary or secondary with some nitrification, and then we had some that were just at secondary, and some of them moved classes during our study period. We also looked at disinfection between UV and chlorination to see if because that was one of the hypotheses in there. So in looking at those 66 out of the 77, we really, again, as Jim highlighted, we really saw the biggest problem was with Cerodaphnia and with Selenastrum. So Cerodaphnia is a water flea, Selenastrum is a green algae. And it didn't really see too much problem with the other ones. And as shown, I'm going to show in these next two slides, really, with these high treatment of effluents, we're really seeing these toxicity units, or where you're starting to see a kind of a break in the curve at fairly low levels. There's for Selenastrum. So now, one of the things about toxicity testing, and we talk about it, is when you have an acute test, and you were talking about before, you have a train that's going down, you have a toxic spill, you know you've got dead fish, or you've got something, you know something's out there. It is a lot easier to find that out, and it's for it's acute. For chronic, it's not as easy because, again, these are organisms. They respond differently, just like you guys might respond differently to different things. Some of them, when we talk about reproduction, there's a lot of variability just within the test. And what really makes things, in order to have a successful wet test, is we really need to be able to see something that's persistent and it has a high magnitude. So if it's persistent and it has a high magnitude, that pink ball can grow. But if it's really small, or it's not even persistent at all, it's going to be very, very difficult to try to determine what the problem is. We also did look at literature again, and I shouldn't say every piece of literature basically says it's really important if you're going to have success with these programs to look at the actual dilution that's happening in the receiving water, to confirm whether or not from ambient tests this is something that's really happening. Again, we're looking at effluent, not the receiving waters. So when we did this, we also we do our routine sampling. We go into accelerated sampling. We looked at almost over 300 tests of accelerated sampling. And then we go into these toxicity reduction evaluations, as was talked about. Cerodaphnia, as you can see, that is out of the 35 places where we're in the Central Valley over the 2-year study period that we looked at. Cerodaphnia was by far the area that we have the most problem. This is not uncommon. This is something that's happening statewide, and Selenastrum being the second. And Jim went over this. I think the biggest take-home that we have is that TREs are really expensive. A lot of time we don't find out what they are, what the causes are. Sometimes we can find it at a treatment plant at what we call the kind of the low-hanging fruit, and we have a permitting approach right now that says, make sure you check that first. We make sure that we have our quality assurance, those checklists that we talked about. But if we're going to have success with these, we really are going to need the persistence, the magnitude, and that's not what we're seeing in the kind of toxicity results we're getting. I think this is when we look at why we concluded. How we concluded our how we concluded this. So you were talking about how do you get out of this do loop? It's when you find the answers. Here's a graphic that basically shows the performance, that low-hanging fruit area that we talked about. That really helps solve the issue. And here's where this 23, or the blue section, is when you don't get, you're testing and it doesn't show up anymore. But what I really pull your attention to is really the only time we actually really find a lot that's in the typical type of test of what is the toxicant, what's the constituent that's causing the problem, versus, hey, we have organisms that are not responding the same as the control. Our success rate is really low, and our success rate is only 2 out of the 35. It's not what we really want to see. The duration, I don't know. The duration, as we look at this, when we were talking about the timing and the cost, this less than 12 months, that's where you're going to be spending. The 6 months, you might be able to get out at 25,000, 125,000. So those were good numbers. It's not these longer ones. We've had over 1 million at one of them. Another one, you know, I'm going to estimate a couple of them in the 250,000 plus. So they're not inexpensive. So in our test, in our study, we looked at what are some things that can cause test variability. So we're looking at different areas. We know we're looking at our treatment plants. We're developing treatment plant checklists. We're looking at the test itself, especially. You know, what is those things that can cause differences? And there's 3 basic categories. There's the inter-test variability, which is that you might do more replicates, you have different cultures, different people, different subsets. We have found, in fact, some of those most expensive TREs were because of microbial interferences. Basically, it wasn't the effluent, it was just that there was either a parasite or bacteria on there. So, and then there's interlab variability. We do it one way, where you might have a different. Well, I'm not going to go in. I'm looking at this. The experience, it might be that it's different food. It could be different. They're still doing the same test. They're doing it per protocol. It's just that there's variable conditions. And then we have interlab category, the interlab variability too. With the interlab variability, I wanted to show you this. This is a individual studies of looking at a bunch of interlab variability for Ceradaphnia, starting with the oldest one. Back when EPA had the method, there was 40 labs that they looked at. And for some reason, there's 40 labs, but you can, to the most recent one, which was done by the Southern California Coastal Research Program in California. These are the number of the labs, but you can see is even when they look at how much variability, we want to see this test get better. We want to see the variability go down and down and down and down because with Ceradaphnia we're getting better. That's not what we're seeing. Ceradaphnia variability is there. It's been there for 20 years. We still haven't figured it out. The State Water Board has recognized that. We've recognized that, and even as we look at more nationally, the variability issue continues to be an issue that's being discussed and is one of the biggest problems that we see. Also, as we have the interlab variability, this just is showing what kind of control water. So if I use a different control water versus an effluent, and I want to let you know that all the first 5 controlled waters are allowed by EPA. If I use a different control water, I'll get a different result. And the ones that have stars, which is these middle 4 here, those would be considered toxic. This one wouldn't be considered toxic, but they're all allowed as a control water. So from our special studies, we developed some tools. We talked a little bit about it. The standard testing sheets, the chronic toxicity review, I think, was talked about. These are things that we're sharing with our POTWs just to make sure that to make sure that we're getting consistency to help both the regional board and our community in trying to save money and trying to make sure that we're moving forward wisely, let me put it that way. But one of the things I actually am most excited about is this, we call it the draft conceptual model. And we showed a little bit about what happened in the treatment plant. Things can happen upstream. We want to be able to look at it. We've been looking a little bit about this. But as we talk about whether it's in the lab or it's in another area, all these areas can deal with variability. And is there a way to maybe say, yes, this is allowed in the method, but if you do this, that, and that, and as a POTW, we contract with our lab to do those 3 or 4 things, we can reduce some of the variability that we would see during that would otherwise cause or indicate toxicity. Right now, we still have a lot of permits that have the SIP provisions. I think Jim talked a lot about what EPA. The pressure that EPA has been pushing on the regional board to include numeric limits. For us, numeric limits are kind of a non-starter. It writes the current legal requirements under the SIP is to use triggers. That was approved by EPA. It is a state policy. We believe you should do it, and until the State Water Board changes that policy, it should be the way that permits are controlled. I want to say we have our frustration is not anything to do with staff or the way that they're trying to handle this. We understand the position they're in. It's just this does put us in jeopardy. We will still have to do the same things, but now we have toxicity violations, and those violations basically say, hey, this is not safe, and we want to know, we want to make sure that, you know, that we want to be able to recycle. We want to be able to use those effluents in safe ways. We think we do. There is a big public perception problem with this too, besides opening us to citizen lawsuits, which are incredibly expensive. And finally, where we want to go, we want to continue to work with the with the Regional Water Board on issues. So we're moving into our phase 2, looking at what are some other ways that we can address those when we talk to those conceptual models. Are there things that we can tighten up? How can we improve the methodology? We want to work on the Ceradaphnia variability with the state, with CTAC, which is an international organization that looks at toxicity testing. I'm not saying that right, but we want to look at them and we want to work with people to get these answers done, because we have really found and have really appreciated this board's dedication to working together to resolve things rather than having everybody go individually and try to work it out. It's been a lot more effective. I hope that in upcoming board meetings, but maybe not so late in the evening, they'll have a chance to talk about 2 other studies that we've done where we work together to resolve some of the regulatory and questions or issues that have been out there. So with that, I think I'm open for questions, and I did it in 7 seconds. I had 7 seconds more, Dr. Longley. So, woohoo! And I have really good experts in the room so if you've got questions, we're going to just invite them up too.
So do you think that the numeric limits are just kind of a backdoor way to get everybody to upgrade facilities?
I don't know where you would go with the Central Valley, because we have some of the highest treatment levels in the state. And our high-level treatment plants are having these issues. It's not we're killing fish. I don't know where we don't see any real benefit to this other than really opening it's not a benefit to us. It's opening us up to lawsuits, kind of dissuading the use of recycled water. We don't see benefits.
Yeah, my outsider opinion is it's what people are putting into the system. Pesticides being flushed down the toilets and, you know, motor oil going down the drain, that sort of thing. It ends up at going through those systems and causes toxicity, acute.
And when you do get toxicity, but oftentimes it's where you have false positives. And my concern is so many false positives coming out of this. Then you get the distrust, or people jumping on with lawsuits, and all kinds of things are happening.
And maybe the approach is more discipline with the labs to be very consistent.
I think I'm caught in the middle here. I'm still trying to figure out whether we should use glass or plastic.
That's right. Glass probably better, but the point is even with good procedures, tell me if I'm wrong, even with good procedures, you're going to get a lot of inconsistency. Am I right? So,
yeah.
There's the expert.
I'm like that going.
Let's hire a statistician.
I'm not going to say I'm a statistician. My name is Stephen Clark. I'm one of the vice presidents at Pacific Ecorisk. And we are an environmental consulting and a testing firm. We have one of the bioassay laboratories in California, one of the largest ones in the nation as well. And we are collaborators with Civiqua on this special study and some others. And I would say that I think and we've actually been kind of on the mountaintop, feeling like we were alone for about 10 years. Dr. Longley, you remember some of the ag stuff we were identifying, some confounding factors.
Yeah, and it's from you that I learned a lot about TRE way back in the dark ages.
Yeah, and so we're happy to I think the reason we tried to get out in front of the confounding factors, whether they be test interferences, microbial interferences, or even interlaboratory related issues, is we were concerned that the science I've been involved in for 30 years in our industry was maybe appropriately getting hammered because of some of these differences, but nobody seemed to be wanting to do anything about it. And so we started doing studies and identifying where confounding factors were, and it's not toxicity, it's a microbe that's interfering with the test, or we were the ones that identified the plating in the algae test, and also the control water slide you saw, among many others. And so we're seeing a groundswell within both the scientific community and the lab community that, these issues need to be resolved. And then also in the international scientific community at CTEC, as Debbie said. And so some of the positive things I see coming is there's likely to be what's called an interest group with the Society of Environmental Toxicology and Chemistry. And one of the goals I have in that is that we're not going to get an update in the methods. EPA's not touching that with a 10-foot pole. But what we can get is what's called a method guidance document. It's kind of a vanilla way to go about best practice recommendations. For which a discharger or a regulated party can say, this is what Lab X, you're going to do this, or I'm not going to contract with you. The issues being identified here in California are nationwide. When we go to the scientific conferences and present these studies, good labs that we know are good labs come by and say we're having the exact same problem in our region. And so if we can get a method guidance document, which won't be a quick process, but given that this is many, many years we've been going through it, I think there will be a tremendous benefit there. Also, as I understand, we'll see if it occurs at the October board meeting with the State Water Board, although there's a whole variety of other compliance issues that the dischargers are concerned about. One of the things that they've conceded is there are some challenges with the Cereodaphnia test that need to be resolved. And they're going to, as I understand from Karen Mogus, they're going to ask for a resolution from the State Water Board to support studies to hopefully address some of the concerns that the regulated community has about that protocol.
Does your staff have complete control over chain of custody of some of the samples from collection right on through?
Sure. So to answer your question from earlier, there are some wastewater treatment plants that have their own labs, and so they'd be the only ones that would literally have the custody, within one system. The vast majority of the dischargers actually collect the samples themselves and will either have them transport them themselves to the laboratory or have it go through FedEx or a courier. Once they get in our laboratory, we have complete custody control over them there. There are very stringent requirements for chain of custody, laboratory accreditations for that as well as one of the elements that's addressed in audits and on-site assessments, is that proper chain of custody has been handled.
Yeah, my experience is you have to be very, very careful on this whole thing.
Everything from how you handle the samples, how you open them, whether you shake them or not. I mean, I can go on and bore you to tears. Not as bad as the statistician might, but ultimately it's very important that the methods be followed and protocols followed, and then even by following the methods, you can get disparaging differences among the labs, and that's where we're really pushing for better resolution within the laboratory community on it. Any other kind of nerdy technical questions on toxicity? I've bored your staff to tears in tours and training sessions and things of that sort, but
I don't know about that, but I thought the word disparaging was good here.
It's for a high quality laboratory. It's very. I'll just be direct. Not every laboratory is good at what they do, and some laboratories that might have been good at what they did 30 years ago. One of the factors in the conceptual model we have is that laboratory experience is one thing, but the personnel experience is another. If your director is no longer there and you get a new cohort of people in your organization, there could be disparaging differences between the laboratories in terms of performance of the protocol. And ultimately that's an issue for ELAP to address, but if we can address some of the method issues within the scientific community to better support the regulated parties and having a higher degree of confidence in these methods, that's our goal.
Any further comments? Thank you very much,
Okay,
Debbie.
well, thank you.
Thank you very much, Stephen. Tom?
So,
What are your thoughts? I think
Who's ordering the pizza?
I think that we need to be talking about this later, particularly maybe after the October meeting, after the state board has had their.
You know, I wouldn't put money on them acting in October. I will say, Adam, of course, dug up. We had a presentation in front of this board in 2010 talking about the impending state board toxicity provisions. US EPA has been asking about this since around 2002. I think there is a lot of momentum to get it done at state board, but I do think October is a bit ambitious. If it was the board's pleasure, a couple of you guys wanted to get together, set up a subcommittee that could look at this issue, I'd be more than happy to help facilitate that.
Volunteers? Dan volunteered. Who else?
Yeah, we get good leadership from our board chair, but I figure it's more clout if there's one or two of the rest of us maybe being in on a conference call or something like that to continue the discussion.
I'd be up to a conference call.
All right.
Very good. Anything else?
Dr. Long, I think there was another interested party that wanted to comment.
Yes, I'm sorry. Come on up. I join the group. Do I have a card?
Hey.
Are you Paul Bedore?
Bedore, yes, Paul Bedore.
Excuse
Thank
me.
you.
I'm sorry, City of Stockton.
Yeah. So my name's Paul Bedore. I'm with a senior scientist with Robertson Bryan Incorporated. I have taken the oath. Do you need my address as well?
Go
It's
ahead.
9888 Kent Street.
Good.
Elk Grove, California, 95624. So I was one of the collaborating team members on the Civiqua special study along with these fine gentlemen here, so it was a great team and some really great information came out of that. Today, I'm providing comments on behalf of the City of Stockton, whose preliminary draft NPDES permit for their wastewater facility contains a final chronic toxicity effluent limitation. So providing feedback at the hearing today was of interest to them, although they don't have a representative here besides myself. How do I advance the slide? All right. Sure. So from our perspective, I want to first communicate to you the results of one particular TRE for a discharger that had a long history of passing their Cereodaphnia test and experienced intermittent test failures only after changing laboratories. So this led us to split the effluent samples for testing at multiple labs. And this chart here shows you the outcomes for 3 split tests. The green boxes here highlight the tests at the new lab, which was Lab A, and you can see in each one of these instances the effluent in the red bars consistently underperformed the lab control. So it was consistent. And here in the middle test, test 2, you can see that was great enough for this discharger to exceed their 1 TUC toxicity trigger. High level treatment, no dilution, have to comply, end of pipe, have a 1 toxic unit trigger. Now here in the blue boxes, these highlight the tests at the other lab, and at these labs, the effluent performed as well as the lab control in all cases. So here you can see the lab variability. And it was these non-toxic test outcomes, labs B and C, that agree with the outcomes of a subsequent biosurvey, bioassessment that we did in the creek that showed that the effluent was not adversely affecting the creek downstream of the discharge. So let's go a little bit wider here. So using the Civiqua study, we can communicate to you results for 17 split tests for Cereodaphnia for high-level treatment facilities, 7 of them, that have that 1 toxic unit trigger. And this chart shows the outcomes of those split tests. The blue bar on the left here shows that in 9 instances, both of the labs found that the sample was not toxic. While on the far right, you can see that the orange bar shows that in 1 test, the labs agreed that the sample was toxic. And here in the middle, you can see that the gold bar shows in 7 tests, the labs had conflicting outcomes and characterized the effluent distinctly differently. And I can drill into that a little bit further. And you can see here that at the lab that found the effluent to be non-toxic, they passed their trigger. Cereodaphnia reproduction, the effluent, it outperformed their lab control by about 8% on average. But for those tests where they didn't pass their trigger, at that lab, they found the effluent to underperform that lab control by an average of 39%. And because were involved with the majority of the TREs where these labs disagreed, we can tell you that they largely concluded without identifying any sort of toxicant, chemical toxicant, or a facility-related issue that was the cause of these instances of toxicity. And so I'll just conclude with the fact that we've heard here today that interlaboratory variability in that particular test, the Cereodaphnia test, is well documented in both the scientific and the regulatory literature. And so what this means for TREs is that when a discharger exceeds their toxicity trigger, it's important to evaluate whether those exceedances really are due to a facility-related issue, as we've been talking about, or a toxic pollutant, or if it's related to a test-related issue. And as your staff have put forward today, the appropriate approach that's making sense and protects water quality is the current approach. It's using that toxicity trigger then to trigger that TRE to investigate those instances of toxicity. And we agree that issuing effluent limitations are simply going to turn these exceedances into violations. And it's even for these instances where that exceedance is due to a testing-related issue, which is something we want to investigate rather than get a violation for. And so we agree, I think, in the consensus, some of the consensus here is that effluent limitations themselves are not going to lead to improvements in water quality per se or wastewater treatment capabilities over this current approach, which itself is working as well as anything else that you're going to get.
Your first two bullets,
Yeah.
That's fine.
Sure.
Particularly for those who delve deep into that. As a regulator, with my regulator hat on,
Yeah.
it's the third bullet that really concerns me.
Yeah.
This is unsettling, to say the least.
Yeah, so for the city of Stockton, they appreciate the opportunity to be able to put these comments forward together, and our consulting team on behalf of Civiqua compiled some really great data. And having worked on numerous of these TREs that went into that evaluation, we can say that there are instances where we absolutely identify a cause of toxicity. I can give you 2 recent examples, and those are being corrected or have been corrected. But it's those instances where you're not figuring it out. The labs disagree, even good labs disagree, that do the best QA/QC. They can come up with different answers to the same question. And so we appreciate being able to give the comments today.
Thank you very much. I shouldn't thank you. Thanks for good information.
Well, this is one of the items I know Adam and I brought this to you, and obviously Carrie and Jim and the stakeholders had a lot to say in it too, because we want to daylight these issues for you. Even in some of the NPDES permits where the dischargers aren't kicking and screaming and making a show in front of the board, these are the issues that we're resolving in many cases behind the scenes. And I do think what's impending at the state board will change a lot of these discussions, and some of those discussions will not change for the better. Again, I understand why they're doing it. I think that some of the test variability with respect to what the labs do, I have some confidence that they can dial that in. They can figure out how to bring labs up to standards. It's those nagging concerns that Dr. Longley focused on, that some of these will result in very expensive processes that will not result in POTW upgrades and will not even track the source of the toxicity. That I want to make sure that the state board keeps in mind as they work forward with their policy.
I'm beginning to think that it's a problem with the Cereodaphnia. I mean, I've heard talk, what's the source? Where do they come from? Who raises them? Are they caught in the wild, or are they raised in the lab?
Yeah. No, it's something
to add a variable.
Smarter scientific minds than me are discussing that issue.
How about a different test entirely to come up with the same answer for?
I mean, I think that's when they talk about the not revisiting US EPA methodology, that's kind of what they're talking about. I don't see it's on the horizon that US EPA will redo their
but long term, I think
another 20 years.
And I think this board's seen a successful example, or with Hyalella and Squirp when they came and spoke with you on Hyalella and how they looked at age of the brood stock with the organisms and things like that, and tightened up didn't change the method, but tightened up the protocol and got better variability. Is it where we want to be? Maybe not quite yet, but it's a lot better.
Thank you, folks. That was I'm going to go out to the restaurant tonight and drink a lot of wine, I think, after hearing that. It's one way to address the issue. We'll see you tomorrow morning at 8:30. Thank you.